Good morning, everyone. I hope you still have some energy for this last stretch of this final day of hearing. It's a short day. Is there anything you wish to raise before we go into? I give you the floor, Mr. Toshingham.
Nothing from the claimant side.
Nothing from the claimant, nothing from the respondent. Then you have the floor, please.
Thank you very much, Madam President, members of the tribunal. Let me give you a roadmap of where I'm going to go this morning in my submissions. I'm going to start with legitimate expectations and just briefly recap a few points there, and also remind you of the other components of the FET standard in the BIT upon which we rely. I will then move to Kriva-Olka and address measures 8 through 10. I will then turn to EIA and address measures 11 through 14, and then I will end with Smilno. So as to legitimate expectations, I would like to, if we could pull up on the screen, if possible, the transcript from day 1, page 8 of the PDF. And this is just a short passage from my opening submissions, which you will obviously recall, but it's probably easier just to take it here. So it's on page 19, at the top, internal page 19, lines 2 through to 11. And so I was talking there about the first legitimate expectation that we say Discovery held. Discovery necessarily expected that Slovakia would not prevent AOG from completing the task. This was the quid pro quo of AOG's obligation to the Slovak Republic. I will do the work, but in return, you will not prevent me from completing it. And that expectation was based on the clear and implicit representation which we say Slovakia made in the licenses when read together with all of those provisions of the Geology Act that I took you through in opening, which emphasized the mandatory obligation imposed on AOG to complete the task.
Now, can I just come in and ask straight away, what is the status of legitimate expectations? It's not in the treaty.
Well, our position is that the FET standard in the treaty is an autonomous FET standard, not limited to the minimum standard of treatment in customary international law. And so therefore, based on the ordinary interpretation, the ordinary meaning of the terms of the BIT, taken together with the consistent jurisprudence of the tribunals who we have quoted extensively in our memorial, our position is that the FET standard in the treaty does protect an investor's legitimate expectations.
So where does it come from? It's not in the text of the treaty. It's not in the negotiating history. It's not in the practice of states. It's not part of customary international law. Where does it come from?
It comes from the ordinary meaning of the terms fair and equitable treatment.
Can you explain that a little bit more?
Of course. Perhaps it would be most easily done by reference to our reply, which is so it's page 135 of our reply, from paragraphs 2, 5, 7, and following. And so this is by way of response to the other side's position that the FET standard in the treaty simply is a mirror of the minimum standard of treatment under customary international law. And here we are explaining why that is wrong and why the ordinary meaning of the terms used in the treaty do protect an investor's legitimate expectations. So this is 257 and following. So if we look,
what does it, sorry to push you,
yes.
But I mean, what does it actually say? What is the legal basis for arguing that legitimate expectation is part of the applicable legal framework? And what is the standard to be applied by reference to the applicable legal framework in what a legitimate expectation is? You've referred to an implicit representation.
Yes.
There's authority that it has to be something more than that. I'd like to know where precisely this comes from, because if your entire case is built on legitimate expectation, we need to know precisely what the source is.
Of course, and may I just clarify on that specific point, we don't rest our case exclusively on legitimate expectations. We obviously also rely on the other components of the FET standard, namely the obligation not to act inconsistently, the obligation to act transparently, and the obligation not to act arbitrarily. But I'm here talking about legitimate expectations. So if perhaps we can take it by reference to the memorial, it might be easier because this is where we set out a case initially. If we go to page 89 of our memorial. So we here quote the terms of the BIT, Article 2, subparagraph 2A, investment shall at all times be accorded fair and equitable treatment. Obviously, in order to then determine the content of that standard, sorry, if we just scroll up, the starting point is the ordinary meaning of the words, obviously well familiar principles, but we've cited many awards here in the footnotes, noting that the ordinary meaning provide only limited assistance, but it's not of no assistance at all. The terms, ordinary meaning of the terms fair and equitable require just, even-handed, unbiased, and legitimate treatment. But significantly, at 2-on-1, the ordinary words have to be read in context, and this is the key point, because if you go over the page to look at the preamble, the object and purpose of the BIT is to provide a stable environment for investment. So in order to ensure that that purpose and object is given full effect, a conclusion that the treaty does not protect an investor's legitimate protection would not give full effect to that object. But I think more importantly, if we go down to 2-on-3 and we then look at the various standards that many tribunals have considered in looking at the broad requirements of an autonomous FET standard, not limited to the customary international minimum standard, legitimate expectations of investors have generally been considered central in the definition of FET, whatever its scope. There is an overwhelming trend to consider the touchstone of fair and equitable treatment to be found in the legitimate and reasonable expectations of parties, which derive from the obligation of good faith. So that's what we say about the ordinary meaning of the language used in Article 2 of the treaty by reference to the object and context of the treaty, and by reference to the jurisprudence of the investment tribunals that we cite. Now, it's accepted, I don't think it's challenged, that in principle, if we go to the counter memorial, our friends then responded to this, and I'll just take you briefly, if this would assist. So this is 89 of the rejoinder, of the counter memorial. So here, I think it's internal page 94, hard copy page 89. So here, the respondent's case is that the BIT imposes the minimum standard of protection of investors established by customary international law, the minimum standard of treatment, and they seek to derive that proposition from the reference in Article 2 to the words "and shall in no case be accorded treatment less than that which conforms to principles of international law." Now, as to that, we say that is a flaw. That is not the ceiling. So you've got to give meaning to the initial parts of Article 2, shall at all times be accorded fair and equitable treatment. So if the states parties had intended to simply mirror the standard of protection provided by customary international law, they wouldn't have included those last words. They would be osios. So that's why we say this is an autonomous FET standard, not simply a standard that mirrors the protection provided by the minimum standard of treatment. So that's the point that we develop in our reply. Then if we go forward in the counter memorial, and this goes on for a long many pages, but we can go forward to 102, internal page 102, PDF 102. So here they're engaging with our contention that the treaty standard protects an investor's legitimate expectations. And 295, 294, while it is widely accepted that protection of an investor's legitimate expectations forms to a certain extent part of the FET standard, it does not protect any and all expectations. So here must be based on specific assurances given by the host state at the time the investment was made and relied on by the investor when making the investment. So it appears to be accepted here by the respondent that if they are wrong in their position that this simply mirrors the minimum standard of treatment under customary international law, they're accepting that in principle, the treaty does protect an investor's legitimate expectations. Now, in the reply, we then responded to that and took issue with the precise requirements for establishing that an expectation was legitimate. I'm sorry, this is taking a bit long, but I think it's helpful. So if we go to the reply, and then we go down to, let me find the exact reference. Yes, and it's page 144 of the reply. And if we go down slightly, it's actually, this is exactly the award I was intending to refer to. So it's a case involving Slovakia. The tribunal in this case, Muzianianka, please forgive my pronunciation, noted that the main components of the doctrine of FET and legitimate expectations are helpfully summarized in the Antares Award. And in that award, the tribunal held a claimant must establish that A, clear and explicit or implicit representations were made by or attributable to the state in order to induce the investment. Such representations were relied on by the claimants, and those representations were subsequently repudiated by the state. So those are the key elements upon which we rely, and that's the test that we embrace. And we say, therefore, it is sufficient for a state to have made an implicit representation in exploration licenses when read together with the legislative background, the Geology Act, provided that those representations were relied upon by the claimants and were subsequently repudiated by the state, then there is a violation of the FET standard. And as to—
So it's an implicit representation.
Yes.
Is the representation in granting a license that the state will prevent protesters from expressing their views, that the investor is no longer required to engage in such other legal obligations as may arise, for example, in relation to an injunction from a court or a requirement that an EIA be carried out or voluntarily entered into? What are the parameters of the representation that is made? I'm assuming you're not saying that with that implicit representation, the investor can now expect the state to prevent protest, to ensure it has no injunctions, or carry out an EIA.
Of course not.
So what's left?
So what we say is, if we go back to the passage in the opening submissions in transcript, if we could bring that up, please, back at page, internal page 8 of the transcript from day 1. So this is lines 2, if we go up, please, yeah, lines 2 through to 11. The key point we make is that because the licenses themselves and the Geology Act impose an obligation on AOG to complete the geological task that it has designed, the quid pro quo, the implied quid pro quo, necessarily requires that Slovakia will not prevent AOG from doing that. And that is obviously right, because you have a license holder who is paying license fees to the state to enable it to carry out this work. It has an obligation to the state to do it, and it is therefore necessarily implicit the state won't prevent AOG from completing the work. And we really didn't hear much by way of response to that in opening. And we just say it follows naturally from the nature of the obligation that AOG owed under the Licenses and the Geology Act. So, and I would also remind you, if I may, what Mr. Solomos said in cross-examination, where I was asking him about the ministry's rejection of AOG's compulsory access order application at Kriva Olka. He said, quote, "It was not in the interest of the ministry to act in this way, to be placing obstacles to companies conducting survey work within Slovakia." That's transcript A3, page 154. So the point is, question the tribunal has to ask itself is, are obstacles being put in the way of AOG completing its work? And when you analyze the measures, but particularly at Kriva Olka, and I'll obviously be developing this later, we say that is the conduct which frustrated Discovery's expectation of being able to complete its work, because unless the lease was approved to enable it to access the site, it wouldn't be able to complete the task. It was prevented from even getting into the site. Equally, when the ministry refuses the compulsory access order based on the instruction from above, that prevents AOG from completing the task. Same when the ministry imposes the suspension, preventing any further consideration of the application.
But I'm just trying to understand. I mean, it happens every day. Every state in the world gives out a license to engage in certain type of activity. Your argument seems to be the moment you grant such a license, you are precluded from having regard to or applying any of your other laws that may be interpreted or applied in a way that could prevent the activity authorized by the license from going forward. And I'm assuming that that cannot be your argument, can it? Because the consequence of that would be that every time a license is given, the rest of your legal order is effectively suspended.
What we say,
That seems to be what you're saying.
we're not saying that this is some kind of implied stabilization clause. Of course, we don't go that far, because there was no such implied stabilization clause in the licenses that were granted. But what we are saying is that when we are applying for permits and approvals to enable us to complete the task, which we have an obligation to the state to perform.
Not to complete the task, to carry out the task.
Well, it's
and
not.
That task has to be carried out in accordance with other applicable laws.
Yes.
And in accordance with the wishes of civil society.
We would not subscribe to the latter point, because that would be that's not a component of the ministry's consideration of every single app. So take the forestry lease, for example. There's no suggestion that the forestry, the Ministry of Agriculture is required to consider whether drilling at Kriva Olka would be consistent with the wishes of society. That is not a relevant part of the consideration that the ministry should be taking into account.
But exploration would be. So the state then has a positive duty to prevent any citizen from objecting to the exploration.
No, we of course we accept that the population, that whether as part of the EIA process, whether as part of the license renewal process, is entitled to participate, and indeed they did. And that is part of the democratic process.
But what if they object?
Well,
the state has to stop that.
No, our complaint is not about the conduct of the activists. Our complaint is about the conduct of the state in making decisions that prevented us from doing the work. So that's the key point.
Far too long. I'm very
it's very helpful, I think, to have the discussion. And I mean, this point is obviously fundamental for damages, because if the tribunal is satisfied that any of these measures prevented AOG from doing the work because of the way in which the permit or approval was refused was part of an unfair process or inequitable process, then the fundamental or most important consequence of that is that AOG is prevented from drilling a well. So if the tribunal is satisfied that these measures breach the BIT, it must then wipe out the consequences of that. And so the most important consequence is AOG's inability to drill a well. So in a but-for scenario, the tribunal would assume that AOG would have been able to drill the wells that it was trying so desperately to drill. So that's how we just stress this link between the obligation to do the work, the obligation of Slovakia not to prevent that work, and what would have happened in a but-for scenario. But of course, as I mentioned earlier, we don't rest our case entirely on legitimate expectations. As I explained in opening by reference to the Crystalex Award, and that's slides 159 to 161 of my presentation, we also rely on the obligation of Slovakia not to act inconsistently, and that seems to be accepted. You can't have one arm of the state denying what the other arm of the state is affirming. And then most importantly, this,
I mean, that happens the whole time in every state in the world.
well,
I mean, that's the nature of government. There are different ministries, and we've all lived through experiences where Ministry A says this is what you can do, and Ministry B says no, we've got to check the environmental obligations, blah, blah, blah. So that proposition cannot be right.
well, the point, our fundamental point on inconsistency is if a state, if one state body, and I'm thinking here particularly about the licenses that were granted and then renewed over a 10-year period. You'll recall that graph, the flowchart I provided an opening. So as part of the license grant, the process of granting the licenses, and as part of each successive application to renew, numerous state bodies are approached, including the district offices, and they are asked, do you object to this expiration? And they don't. So over a 10-year period, that is the conduct of these state bodies who are approached. And so our complaint on inconsistency is that when the district offices then impose the EIA decisions in 2017 and 2018, which put a halt to the project pending a full EIA, that is an instance of inconsistent state behavior by the very same state body. And so that is what our real complaint is in relation to inconsistency. But of course, we also rely on the obligation of the state to act transparently and non-arbitrarily.
I may have some questions later on the components of legitimate expectations. But I just want to be clear. You seem to be distinguishing, if you will, the licenses here by insisting on not only their permissive nature, it's a right to do something, but the requirements
Exactly.
in the licenses themselves.
Exactly. And that is the key point. And so a state is fully at liberty, whether or not to grant these licenses and impose that obligation. But when that obligation is imposed on the contractor in the licenses and in the Geology Act, and when an investment is then made in Slovakia in reliance on those licenses, which was obviously the evidence of Mr. Lewis, which went unchallenged, that has consequences at the international level. And that is our key point on legitimate expectations, from which we don't really hear, from what we've heard so far, a credible answer. So that's all I'm going to say, unless the tribunal would like to hear anything more on those points. I'm sorry it's taken a bit longer.
You should move on, because
yeah.
otherwise we'll hear.
I just wanted to clarify that the sort of questions and the interactions we've had, obviously that was longer than I was intending to expect to take, but I'll move as quickly on as possible to Kriva Olka.
I don't need to tell you that anything you have to say in response to the tribunal's questions is very relevant.
Exactly, and I'm very glad to assist you as much as we can. So I think it would be helpful just to begin with 3 contextual points about Kriva Olka. And the first is this: it was barely touched on during our friend's opening presentation. It was said, quote, "We need not spend much time on it." And it is easy to see why. Because if Slovakia had a good defense to our allegations at Kriva Olka, we would have expected to have heard it by now. It was barely touched on, it was not touched on at all in cross-examination of Mr. Fraser or Mr. Lewis. And apart from my questions in cross-examination to Mr. Solomos, on which more shortly, you heard nothing from any other witness on Slovakia's side. Now, the second key contextual point relates to the March 2016 election. And that is a key event in the chronology here, because I explained in opening that new ministers and officials were appointed after the election, and it is clear that those appointments had repercussions for the approvals that Discovery needed at Kriva Olka. Now, in this regard, consider what AOG was being told by Ministry of Environment officials at a meeting shortly before the election on the 9th of February 2016. And this is touched on in Mr. Fraser's first witness statement at paragraph 43, but you can see more from the underlying note of that meeting at C124. If I could ask for that to be brought up, please. This is not a document we have seen before, but Mr. Dreimer, you will recall you mentioned a reference to Mr. Fraser's first witness statement, and this is the underlying note to which reference is made. So this is a meeting between AOG and Mrs. Matover, and you'll recall that she was the director of the Department of State Geological Administration and another MOE official. Second paragraph, quote, both one fully understand, the English is not great, I'm afraid, but we'll do our best. Both one fully understand our troubles. Few months are attacked by activists and administration. Just today, finalized a letter for the president. And just pausing there, it's clear the project was being discussed at the highest levels of government, even before the election in March 2016. The bullet points are also important. First bullet point. The situation in oil sector is new for everybody. Ministry has no force to help us. Ministry support Alpine in all what is in its responsibility. And I'll come back to some of these bullet points in a moment and what we draw from them. Just moving down a few more bullet points. Geological department, that's obviously the department in which Ms. Matover worked, is permanently attacked in last few months. And in all case, confirmed that Alpine activity are 100% legal and Slovak state guarantee right to make exploration there. And then if you move down a bit as well, the next bullet point, Ministry Department supposed that in the last months, increased situation is linked with the election campaign. Ministry supposed that after election, a situation will be more normalized. And then the final bullet point, Ministry ask for patience. What do we draw from this email and Mr. Fraser's testimony at 43 of his first witness statement? Well, the ministry, specifically the department that Ms. Matover worked in, were already under significant pressure as at February 2016, based on the activists' media campaign against AOG's project. And that pressure intensified after the election, as we saw from documents such as C348, and that was the article where the former Prime Minister of Slovakia was attacking Minister Solomos for having extended the exploration licenses, and documents such as R162. And we also refer here to Mr. Fraser's testimony at transcript day 2, page 133, line 15, through to page 134, line 10. Now, this is a key contextual factor, the media pressure, which is relevant to all of the impugned measures, but particularly at Kriva Olka. The second thing we draw from this note is that the permanent officials at the ministry, at the coalface, who were dealing with AOG, specifically Mrs. Matover, were supportive of AOG and were suggesting that the situation would become more normalized after the election. Now, that prediction ultimately turned out to be wrong. The prediction after the election was far from normalized. And again, this is another key contextual factor, which we say lends strong inferential support to the notion that an instruction was given from above to refuse AOG's application at Kriva Olka. Conversely, the fact that the permanent officials at the coalface were supportive makes it highly unlikely that it was those officials who were responsible for refusing the application. That's all I was going to say about this document. And the third contextual factor is that after the election, AOG's project, and specifically the drills at Kriva Olka, became a political hot potato for the government. There was negative coverage about the project throughout the national media. As Mr. Solomos confirmed, that's transcript day 3, pages 131 to 132. Mr. Solomos described the situation as, quote, a sensitive issue. That's transcript day 3, 157, lines 19 to 22. And Mr. Solomos confirmed that the Ministry of Agriculture and the Ministry of Environment were controlled by different political parties. You'll recall SNS were in charge of the Ministry of Agriculture and MOST in charge of the Ministry of Environment. And we say it is clear that each ministry was trying to pass the parcel from one ministry to the other to avoid having to make a decision in AOG's favor. So those are the contextual factors that I would just ask you to bear in mind when you look at the individual measures. So I'll begin with measure 8, which is the MOA's, Ministry of Agriculture's refusal to approve the amendment to the lease. We don't need to look at this document anymore unless you would like to. So I'll begin by reminding you of who you did not hear from on Slovakia's side in relation to this measure. The Minister of Agriculture herself, Gabriela Mateshna. She was the person who wrote to AOG on behalf of the ministry on the 23rd of June 2016, refusing to approve the amendment to the lease, C19. Slovakia did not even mention her name in opening. They put forward the Minister of Environment, Mr. Solomos, as a witness, but not the Minister of Agriculture, and that was evidently a tactical decision, we say. The second person who you didn't hear from, and he is a key person, is Mr. Regets. He was the head of the service office of the Ministry of Agriculture. And again, we heard no reference to his name in opening. It is clear from the documents in our opening presentation at 100 to 103 that he was the person who had the competence to approve the amendment. He was the official with the most important evidence to give about the Ministry of Agriculture's internal decision-making process. He was nowhere to be seen. The important point there is that the documents I took you to in opening at slides 102 to 103 show that Mr. Regets was from the SNS party, which was in charge of the Ministry of Agriculture. He had based his pre-election campaign on opposing AOG's project. And after he was appointed as the head of the service office, he was using his position to withhold approval for the amendment for an improper purpose. And somewhat remarkably, there was no response to any of this in opening or in evidence. Slovakia has also not explained its failure to disclose any internal Ministry of Agriculture documents which reveal the decision-making process which led to the refusal. And it has also not explained why these two people have not come here to explain their conduct. In opening, it was said, quote, the bottom line is that AOG failed at Kriva Olka because it made a mistake. It didn't request the lease extension by the deadline. That's transcript day 1177. But I already explained why that case theory does not work in opening. Whether the lease extension request was submitted 1 day late or 7 days late does not matter. The State Forestry agreed to extend the lease by signing the amendment on the 14th of January. And it's conceded that State Forestry was an independent entity and therefore had authority to take that decision. It was suggested in opening that the Ministry of Agriculture needed to give its approval within the 30-day period between the 15th of December and 15th of January that was specified in the lease. But the ministry was not a party to the lease. No such provision was set out in the lease as to why that period was included. And then most importantly, there was no time limit specified under Article 50, subparagraph 7 of the Forest Act, within which the ministry needed to give its approval. This was an entirely separate administrative process. So as at the date of the amendment, the lease was not dead, which is the word that was used in opening by Slovakia. The lease was extended by State Forestry, but needed to be approved by the ministry. Now, The only other point that was raised in opening in relation to this was a reference to AOG's letter to State Forestry on the 18th of July 2016. That's R161. We could just pull that up, please. So recall the date of this document is after the Minister of Agriculture has refused to approve the amendment to the lease. And Slovakia points to the fact that in this document, if we scroll down, please. So you see a reference here in the second paragraph to the original lease agreement, and those are important words. It's a reference there to the original lease before the amendment. And then on the last line, after 5 months, the ministry justified its disapproval of the amendment by the fact that the original lease agreement expired and the formal requirements were not fulfilled. And then go over the next page. Since the original lease agreement has expired, it is not possible to renew it with an amendment number 1. And therefore, that's why a request is made to State Forestry to enter into a new lease. But this letter was obviously sent after the ministry had already refused to approve the amendment. And of course, as at that date, then the initial lease, the original lease agreement had expired. So it wasn't possible to renew it with the amendment because of the ministry's refusal to approve the amendment. So we say, in short, the Ministry of Agriculture's conduct in Measure 8 was a textbook example of an FET breach. It prevented AOG from drilling the Kriva Olka well and therefore violated Discovery's legitimate expectations. It involved Slovakia acting inconsistently, and for good measure, it involves Slovakia acting non-transparently and arbitrarily. Now, if the tribunal is satisfied that Measure 8 was a breach of the BIT, the tribunal need not go on to consider whether Measures 9 and 10 or Measure 13 are breaches of the BIT. Now, why is that? Well, because in a but-for scenario, the amendment to the lease would have been approved well before June 2016 by the Ministry of Agriculture. AOG would have therefore been able to access the Kriva Olka site and drill its well before the expiry of the initial term, the extended term, that was extended until August 2016. And importantly, AOG would have been able to drill that well before the amendment to the EIA Act came into force on the 1st of January 2017. And in that regard, we refer the tribunal to Mr. Lewis's second statement at paragraph 23 for the timing that it would have taken to actually drill the well and conduct the flow tests. So all of that could have been done. And that's why we say on that ground alone, Measure 8 is enough for us to win on Kriva Olka. But if the tribunal wishes to go on to consider Measures 9 and 10, this relates to the Ministry of Environment's conduct in refusing the order, we say also that conduct breached the BIT, and I will take this as quickly as I can. And here I'm going to remind you again of who you did not hear from on Slovakia's side. 3 permanent ministry officials who had been working for the ministry since well before the 2016 election. First, Ms. Yanova. She was the Director General, DG, of the Geology Directorate. It's transcript day 3, 105, lines 10 to 11. She had been the Director General since at least 2011. Ms. Matova was the Director of the Department of State Geological Administration. Transcript day 3, 104, lines 12 to 22. She was Ms. Yanova's deputy and had been the Director of the department since at least 2014. She signed the 2014 licenses, that's C8. And the third official was Mr. Hervol, State Councillor of the same department. He was a junior official, and Annex 11 to our opponent's letter dated the 29th of January 2024 shows that Mr. Hervol's job description was signed in 2011. So he'd been there for a long time. They were the officials at the coalface who were dealing with AOG's application. They were the officials who had relevant evidence to give to explain what happened internally, but they were nowhere to be seen, and no satisfactory explanation has been given for that. The next point, leading on from missing witnesses, relates to the missing documents. Now, we learned during cross-examination that Mr. Solomos usually attended weekly ministerial meetings with the DGs of all departments, transcript A3, 103, lines 5 to 9. He recalled that the ministry took meetings of those minutes, page 105, lines 12 to 14. It's likely, we say, that those minutes would have provided evidence of the ministry's internal consideration of AOG's application, not least because, in his evidence, he explains that the entire AOG issue, the whole case, was an important event for a ministry, even for myself. We say it is very likely that those minutes would have referred to the application. There are also likely to be other internal documents which have not been disclosed. You'll recall that Mr. Solomos accepted it was likely that Ms. Matova and Mr. Hervol would have been involved in internal discussions at the ministry about AOG's application, transcript A3, page 117, lines 6 to 9. And also he accepted that Ms. Yanova and Ms. Matova communicated with each other, page 141, lines 14 to 24. We heard nothing again in opening by way of an explanation for these disclosure failures. And during Mr. Solomos's cross-examination, you will recall I pointed the reference to file number 2205-2017 in the top right-hand corner of the ministry's decision in March rejecting the application. That's transcript A3, 158 through to 159. Mr. Solomos confirmed that he had not looked through that file before he came to give testimony. It's page 160. And it seems highly likely that the prior drafts of the ministry's decision, to which I'll come to shortly, would have been held within that file. No satisfactory explanation has been given for the failure to produce those prior drafts. The next point here relates to the famous email exhibit C370. If we could bring this up, please. So this is the email on the 9th of March, which you will have seen many times before. And the question here is whether the tribunal can be satisfied that Mr. Hervol made the statements that are recorded in this email from AOG's attorney. We say the tribunal can be so satisfied for 4 reasons. The first reason is this is a contemporaneous record of a conversation between AOG's attorney and Mr. Hervol. If you scroll down, please, to the bottom, you will see that on the 8th of March, a colleague of Mr. Beran's says to Mr. Fraser, since the period has expired, tomorrow we will also chase Mr. Hervol regarding the section 29. And if you then look at the email at the top, the very next day, we talked to Mr. Hervol regarding the decision under section 29. So it's a contemporaneous record. The second point is the tribunal is entitled to attach significant weight to a contemporaneous record of a conversation written by an attorney and reported to his client. There is no suggestion that the attorney had any motive to conceal or misrepresent matters. The third point is that Mr. Hervol is not a witness within Discovery's control. He is an official within Slovakia's control. It would have been the simplest thing in the world for Slovakia to produce a witness statement from Mr. Hervol denying what is set out in this email, but they have not done so. They have known about this allegation since the memorial, paragraphs 152 to 153, and the reply, but no witness statement came forward. And the fourth point is that Slovakia has not produced internal documents which contradict the account set out in the email. Documentary exhibits that we have placed before you are consistent with the account set out in this email. And we rely here by way of example on exhibit C337. That's the email dated the 17th of October 2016, where Mr. Hervol is said to have confirmed that he saw no reason why the ministry should not decide in favor of AOG. It's entirely consistent with what is set out in this email. And then Exhibit R213, which is Mr. Fraser's email dated the 15th of December 2016, reporting on his meeting with the minister that day, where they discussed the Article 29 application. And was led to believe the application would be approved, and that the minister was prepared to help AOG, but only if he got some positive PR. What then should the tribunal make of Mr. Solomos's denial in his witness statement, his second witness statement, that he ever gave an instruction? Well, Slovakia's legal team appear to have made a tactical decision not to inform Mr. Solomos about the allegations made by Discovery in its memorial regarding the application. And you'll recall transcript day 3, page 111, line 17, through to 113, line 12. No, I was not informed to speak on this issue. He didn't even know at the time of his first witness statement that this was an issue. That is a tactical decision which is revealing and builds on the points I've already made about Slovakia having no credible defense to the Kriva Oka allegations. Instead, Mr. Solomos addressed this issue for the first time in his second witness statement in 3 short paragraphs, but he was relying on his own attempt to recall events which had occurred nearly 7 years earlier in 2017. And this is transcript day 3, page 113, lines 22 to 23, quote, I only had information that I remember. 3 further things became apparent in cross. First of all, apart from the documents mentioned in his witness statement, he had not been shown any other internal Ministry of Environment documents relating to AOG's application. It's pages 113, 115, and page 142. He didn't speak with Mr. Hervol before he came to give evidence, despite the fact that it would have been obvious to speak to Mr. Hervol. And then third, and this is the key point, he had not even seen this email that's on the screen before he came to give evidence. This is transcript day 3, page 154, lines 2 to 16. So he'd not even seen it. We say that is very revealing. Doesn't provide a promising start to give any weight to his testimony. But it became worse because he accepted that his recollection may be different if he'd been able to refresh his memory by reference to the contemporaneous documents. Transcript day 3, page 149, lines 3 to 22. Quote, well, definitely, I don't remember everything from 7 years ago. I would be reading hundreds of documents back then. Had I seen something later on recently, I would have remembered. It's quite logical. Now, Mr. Solomos suggested that if he was the appellate body, he would not enter or interfere with first instance decisions. But you'll recall, Madam President, that in response to your questions, you were asked, he said, he accepted that usually he would not have been able to have been involved in first instance decisions. And that's transcript day 3, pages 150 to 151. So there were exceptions. And it is inconceivable that in this case, where the minister himself described the AOG issue as an important event for the ministry and himself, and where he had attended a meeting with AOG on the 15th of December, where the application was discussed, that he wasn't involved in any way in the decision. So there are 2 possible explanations with which you are left. The first is that the minister did give the instruction, but he's forgotten. It's not surprising, given the passage of time and the fact that he hadn't been able to refresh his memory by reference to the contemporaneous documents. Or someone else from high levels of the ministry gave the instruction, but Slovakia has not identified that person's name. And because of the disclosure failures, we don't know what went on. So we say it is more likely than not that it was the minister who gave the instruction, and had he been able to refresh his memory by reference to all of the internal documents, then his recollection most likely would have been different. But ultimately, we say the email is clear that an instruction was given. When you take it all together, it all points in the same direction. Now, the final point on this is Slovakia says, well, the instruction theory can't work because in June, the minister granted AOG's appeal granted the appeal in AOG's favor. That was day 1, transcript page 181. Well, Mr. Solomos didn't grant AOG's appeal. He annulled, as you recall, the original decision and remanded it back to the ministry for a new decision. You will recall that in Cross, an issue arose about whether the minister had the power to annul and remand or annul and amend. We have sent you overnight, you may not have seen, but exhibit R076A. This is articles 59 and 61 of the Administrative Procedure Code, which show that the minister did have the choice either to alter the original decision or to quash it and return it back to the first instance authority. So the minister could have granted AOG's application within the context of the appeal, but he did not. If the minister had exercised that power, that would have likely generated further negative publicity, which the minister was so keen to avoid and the ministry was receiving. And so the appeal, we say, is not a complete answer, and it didn't remove the existing obstacle which the ministry had put in AOG's way. But in any event, we say the reliance on the appeal is a non sequitur. The mere fact that the minister quashed the original decision doesn't negate the proposition that an instruction was given before the original decision was issued. The final point then is Slovakia says, well, Discovery walked away from the process after the decision was quashed. That was transcript A1, page 182. But that is a complete distortion of the facts. The tribunal has this point already, but we refer to our reply at paragraph 141, and you will have seen what we said on that. So again, we say the ministry's conduct under measures 9 and 10 were another textbook example of an FET breach. They frustrated Discovery's legitimate expectations. They involved Slovakia acting inconsistently, and they also involved another non-transparent and arbitrary behavior. So that's all I was going to say about Kriva Oka, unless the tribunal has any more questions. I will now move on to EIA. So the tribunal asked yesterday, how do we reconcile Mr. Lewis's oral evidence that the EIA was the, quote, nail in the coffin, transcript A2, pages 224 to 225, and AOG's voluntary offer to perform the preliminary EIA for the 3 exploration wells in the April 2017 press release. That's C171. Now, it's important that we be clear about what we mean by the EIA issue. And I think it would be helpful if we could begin with our opening presentation, slide 124. I promise no new slides, so this is an old slide. Please, yeah. So CP1, slide 124.
While we're waiting, can I just say personally how nice it is to have you doing advocacy rather than reading from a PowerPoint?
I quite agree.
It really is
Yeah.
a lot nicer as an arbitrator to hear you doing your stuff.
Thank you very much, Professor. Do we have this on the screen or not? Oh, great, perfect. If we could go to page 124. If you see on the right, just where there's the dialog box above 214, if you could just type into there 124. To save having to press.
Numbers on the right-hand column, right at the end. I know this is the new Adobe.
Yeah, it's changed
That was
recently.
updated last week. You can switch back to the old version if you want.
Do you see on the right-hand side, just above? Oh, yeah. Okay, fine. Apologies for the delay here. I mean, it was also one of the demonstratives. I wonder whether that's quicker to pick that up in that way. Oh, yeah, there we go. This is probably easier. That's fine.
Demonstrative one.
Yeah, okay, exactly. This is the right slide. So I skipped over this slide in my opening, for which apologies because time was short. But obviously, I think it's just important to emphasize a few points here. The first step in the EIA process was the applicant submitting a preliminary EIA to the district office. And that was the voluntary step that AOG committed to take for its 3 exploration wells in the April 2017 press release. But importantly, under the Act, that step did not automatically lead to an order for a full EIA. The second and third steps are the gravamen of Discovery's complaint of a BIT breach. So the district officers had to conduct proceedings to decide whether a full EIA was required. And after conducting those proceedings, the district office then issued a decision on whether a full EIA was required. And at that stage, step 3, the district office could either say, no, we don't require a full EIA, or yes, we do require a full EIA. It's common grounds, and this is slide 131 of my presentation, we don't need to go forward to that now, that an order for a full EIA could only have been made if the district officers were satisfied that the activity was likely to have significant effects on the environment. And so this is the key complaint, and this is measures 11 through 13. In order to comply with the FET standard in the BIT, an order for a full EIA could only have been made after conducting a procedure which was not arbitrary and in which the applicant was treated fairly. That's the words of the tribunal in Crystalex at paragraph 581, slide 159 of my presentation. So when Slovakia made the EIA decisions requiring a full EIA, measures 11 through 13, it breached that standard because it acted inconsistently, it acted arbitrarily, and it frustrated Discovery's legitimate expectations. And it was those decisions which were the final nail in the coffin. And I'll go through this in a bit more detail if it would assist the tribunal. Next, I think it would be helpful if we could go back to slide 122. And this is the timeline. So what we're talking about with measures 11 through 13 are the 3 EIA decisions. And they, of course, came after AOG had made a voluntary commitment to the activists to perform the preliminary EIA. But of course, our complaint is about the treatment which we suffered at the hands of the state in those 3 decisions. So that's I hope that helps the tribunal reconcile those two aspects, unless the tribunal can help you any further.
We were taken to a document, and I can't remember, I got it in my notes, which summarized the process between step 1, preliminary EIA, and a document which described I think the 174 people who contributed, and then state organizations, and thereupon a decision was taken.
Exactly.
So could you just tease out a little bit more what went wrong in that process?
I'm going to do exactly that, Professor. So but just before I go to that, can I just set out why we say there was a breach of the FET standard in relation to these measures? So we say, we've addressed this point in detail, and it's reply at 165 through to 175, which is the facts, our factual examination of the EIA decisions. And then our complaint on liability as it is at paragraph 318, and then 335 subparagraph 2 of the reply. So that's where we've pleaded the point. And we say, first of all, Slovakia acted inconsistently when it made these EIA decisions, because Slovakia had previously concluded that AOG's exploration activities were not likely to have a significant adverse effect on the environment. And I'm referring there specifically to 2 things. The first is, do you remember during the license renewal process over that 10-year period between 2006 and 2016, at each stage, the district officers were asked whether they objected. And some of the questions that were raised were whether there are environmental objections to the exploration. And at each stage, the district officers said, no, we do not object.
But would that mean that when you go into the preliminary EIA process, you expected that in any event, there would be no decision for a full EIA
Precisely.
because somehow the decision was already preempted by the prior decisions on or observations on the lack of negative impact.
Exactly, but I think rather than saying preempted, perhaps how we would put our case is that when AOG submitted these applications, it did so against the background not only of those non-objections in the license renewal process, but critically also Minister Solomos's statement in January of 2017, and this is slide 140. Perhaps we could just go to that because this is also quite important. So this is the 8,000 wells point. You remember I took you to this in opening. So what matters to local people can be assured that the activities will not have any unfavorable impacts on their surroundings and the environment in general. And then critically, the paragraph, to this day, we at the ministry are not aware of even a single environmental related problem occurring as a consequence of those wells. Now, we of course don't accept that that alone can amount to inconsistent behavior, but we point to that as an important contextual consideration when the tribunal examines the EIA decisions, because the tribunal can ask itself, when the district officers then issued their decisions a few months later in 2017, what was suddenly the very large environmental problem that was supposedly caused by these wells? Because you can't just make a decision for a full EIA on the basis of speculation. In order to comply with the BIT, it has to be based upon a rational foundation of fact, the suggestion that the drill would have a significant effect on the environment.
Would you accept that if you make an offer for a preliminary EIA, then if the EIA is correctly conducted and it comes to the conclusion that there is a risk for the environment that requires a full EIA, then you have accepted
We
this.
completely accept that. And
so you're more complaining about the fact that the investigation was not properly conducted? Is that what it is?
In large part, yeah. And we would put it as and draw an analogy with the Crystal X case, because we see that's the clearest analogy that we can draw with another case that has considered similar issues. Now, of course, that was not a case involving an environmental impact assessment, but it was a case where a permit was denied on purported environmental grounds. The tribunal concluding that the way in which those environmental grounds were raised did not follow a fair process. And the point was that in that case, the tribunal said, in order to put a halt to the project on environmental grounds, that those grounds needed to be supported by evidence and data. And it was incumbent upon the state to support those allegations by reference to a foundation of fact. And if we just look at the Smilno EIA decision, and this picks up on Professor Sands's point. So if we go to 37777, please. No, exhibit 377. C377, yeah. So this is the Smilno EIA decision, which was handed down by the district office on the 2nd of August. And we've obviously referred to this in our slides. So the district office, upon the application by AOG, and you will see the application at C373, which we don't need to go to now. But the conclusion is that it shall be assessed pursuant to the EIA Act. And that is the order for a full EIA. And if you then scroll down, please, do you see the heading reasoning? So the key point here is that this decision, I'm afraid, I can only describe it as a travesty of a decision, because if you scroll through, you see that pages 1 through to 3 are a summary of AOG's application. And you'll see that if you look more detail at the application at C373.
And it's an application for a preliminary. is it
Correct,
not?
exactly. This
Yes.
is the preliminary EIA application, and it was prepared by a professional consultant called Kempro. It spanned 37 pages. It included 6 further annexes, and the whole purpose of the application was to explain why the activity, the well, was not likely to have significant effects on the environment. So that's the baseline against which the decision has to be judged. Pages 4 through to 55 of this document then quote verbatim the 55 comments that were submitted by the various bodies and citizens. And it's interesting to have a look at some of those comments. So if you could go to page 9, please. Page 9. Oh, yeah. So comment number 6. This is the Bardejov District Office, Department of Road Transport and Land Communications, sending a letter on the 12th of July. And it's obviously received the application. And the issue is actually access. How do we access the site? So what does the district office say? Quote, the proposed site is accessible from a comprehensive road, dirt road, connected to the road in the cadastral territory of Smilno. So this is the district office telling AOG and the other district office that AOG can access the site using the field road. But what is then said in the next paragraph is, in view of the Road Act, state administration in matters of local and comprehensive communications is carried out by municipalities. And you'll recall that that was Professor Stevchek's precise point. This fell within the jurisdiction of the municipality. And so the Bardejov District Office says, quote, we refer the matter to the municipality of Smilno for the direct handling of this matter. What does the Smilno Municipal Office then say? Look at number 7. The municipality of Smilno, represented by the mayor, has no objection to the, and that's the project, concerning access from the main road, dirt road, connected to the class 1, number 111/77. So what we understand there is being said is you can use this road to access the drilling site. Now, of course, some other citizens and some state bodies, including another municipality, objected, and they insisted on a full EIA. But the question is whether, if you go forward to the conclusion at page 55, so is a heading entitled Conclusion, and then this is the sum total of the analysis. And I would invite the chairman to read this very carefully in due course. It doesn't really say very much in the first paragraph. It says we took into account the opinions and made the ruling set out in the operative part. And if you go forward to the next page, and at the top, from the opinions received on the project proposal and from the measures proposed in the design construction operation, some specific requirements in relation to the design construction operation have emerged, which will need to be taken into account. Other requirements will be specified in the scope, and that's obviously at the next stages in the flowchart. So our key point here is that if you are going to put a halt to the project on the basis of environmental grounds, you needed to explain by reference to a rational foundation of fact why the activities were likely to have significant effects on the environment. And we say that the district office's failure to do so did not accord with treatment that can be termed fair and equitable.
You've taken us at page 56. Other requirements and details will be specified in the scope of the assessment.
Yes, that's the full EIAs. That's
Well, other requirements and details will be specified in the scope of the assessment.
Yes. So if you go back to the flowchart in my presentation.
Other requirements. I may be just wrong. I'm reading that as being the full requirements of what is to be assessed will be set out in the future decision.
We understand, I mean, it's accepted, I think, on the other side, this is the order for a full EIA to take place. If we go back to the...
So what does that mean, other requirements and details?
If I could just take you to the flowchart.
Yeah.
This is at slide 1.
But also, relatedly, how does this decision compare to other decisions in relation to this document and decision adopted at this stage of the process. Is this different from other decisions? Does this depart from normal practice?
No, maybe I had the same
yeah.
question. What is the legal basis in Slovak law for this process, in the sense of what is the administration
Yeah.
meant to do? Does it
course.
have to investigate?
Yes. So if I could take you to the flow chart, this is the key. This puts it in the legal basis. So if we go to slide 124. So
You're being asked, what exactly are the proceedings?
Exactly. So
in box
it's
two
so in box
meant
two
to
and
be?
what in box 2 and box 3, those are the provisions of the EIA Act, which establish what the district office has to do. And we've got the references in the footnote to those articles in the Act. And if you turn to the Act, I don't think we have time given now, but they set out that the district office must take into account a wide range of factors, and they are set out in an annex explaining what has to be taken into account. You can't just order a full EIA on the basis of speculation. It's got to be based on some rational foundation of fact. And so
I mean, just on that, if you look at the third box, district office issues a decision on whether a full EIA is required. I assume that is that's C377.
exactly.
Then the next box says if a full EIA is required,
If an order for a full EIA has been made.
which it has.
Yes.
District office then determines the scope of
Correct.
the full EIA.
So then
So we
that,
haven't seen that yet,
Those are the further
particularly.
criteria.
so if you then look at R193, that then takes you to what the district offices then require to be done. But this is, of course, after the order for a full EIA has been made. So you're already, once that decision has been made, you then open up the full EIA process. So this is the scope of assessment. And you see here then, later down the page, on page 2, a bit further down. So this is the scope. So this is specific terms. So what's being said here is then you need to elaborate in detail on all of these matters. So this is what then has to be done. Now, what we say is, if there was a concern about, for example, contamination of groundwater, if that was the only objection which was raised, or which the district office had at the screening process, at the preliminary EIA process, then the order for a full EIA should have been limited to that specific issue, because that was obviously one of the issues that the activists were concerned about and which were raised in the comments. But instead, we get a full scope EIA on everything. And we say the problem here is that all of these specific terms, the concerns that these issues would have a significant impact on the environment, just did not have any rational foundation of fact. And so at the screening process, we shouldn't have even got to this process if the district officers had done their job properly.
But again, sorry, I'm just trying to
Yeah,
understand the process. So this document now, we're now November.
Correct.
So it's September, October, no, 3 months later.
Exactly.
They've now come up with the full detailed scope. I'm just now trying to work out in parallel in my mind.
Yeah.
We've got this entire process with the EU directive.
Yeah.
Which has wrongly been transposed by the Slovak state into domestic law.
Yeah.
There are proceedings against Slovakia for that. They then have to amend their adoption of their
Which was
rules,
January.
which was January.
Yeah.
In the meantime, there's been a judgment of the Court of Justice of the European Union,
Yeah.
which says that in certain circumstances, exploratory drilling may be the subject.
And we fully
understand.
Yeah.
But what I'm trying to work out then is, to what extent does this EIA requirement,
You mean this document?
the November R193, November 2017, purport to give effect to the requirements under the EU directive? Because the EU directive, once it requires an EIA, doesn't actually operate to, if you like, home in on the particular areas of concern. Once you're subject to that requirement, it's the full whack. So you're saying they shouldn't have done
Correct,
that. And I'm
correct.
trying to understand the basis against this background on which you say they fell into error by requiring, if you like, a full EIA
Yeah.
rather than a partial full EIA. You may be able to explain that, but I'm just
the-
trying to work out.
No, I think that's helpful to, because I think what we would say is that if these were the concerns that were troubling the district offices, district office at the date of the August decision, then in order to comply with the BIT, the district offices needed to be transparent with AOG and tell them during the process, these are the specific concerns we have. That is what a state must do. It is not enough simply to make the decision and then later on say, we have these concerns, because if they had been raised earlier, AOG would have then been able to say, well, look, this is what we say in our application, and this is why the chemicals that we are using will not pose significant effects on the environment. And we can satisfy you that this won't pose a problem, but they didn't do that.
But again, I'm just trying to understand.
Yeah.
It's a complex and moving
I know.
situation here because of two processes going in parallel: the EU process and the Slovak process. The way the EU process works, I know nothing about the Slovak process
Yeah.
beyond what I've learned in these proceedings, but I do know the EU process well. There isn't a possibility for, if you like, a partial EIA. Once you fall within the scope, you've got to do a full whack. So what you're saying is they had a duty to set out with precision
Exactly.
what the particular areas of environmental concern
Were
were
before the August decision.
before the or in the August
Exactly,
or in the
yeah,
August decision.
yeah.
But I then have two questions. The first is, does this set of steps depart from what happened in other projects in Slovakia? And secondly, what is to be done in the circumstance that EU law apparently, I'm not expressing a view on it, but apparently requires you to do a full whack EIA, however absurd that may be. That's apparently what the EU law requires.
Do you mind if I just take 2 seconds
Please,
just to, because
please
I think
do,
this is an
yeah.
important point, but I'm conscious we're
Yeah.
Could I just help you on come back on the EIA directive point, if I may? I mean, entirely in the tribunal's hands if you would like me to elaborate on this, but I think it's important. And then I'll come back to the specific decision in this case. So if we could pull up R083, which is the EIA directive. And page 4. So the project with which we were concerned was listed in Annex 2, not in Annex 1. So subject to Article 2.4, for projects listed in Annex 2, member states shall...
But you're aware of that.
I know.
And which is almost incomprehensible,
I know.
actually, to read.
But just taking the language of the directive itself.
But then you're going to have to take us to the judgment, because the judgment basically says that an exploratory project on Annex 2 may nevertheless be subject to a mandatory requirement. That's the difficulty.
Well, I just want to
because this alone doesn't sort out. My reading was probably as yours was.
I know.
It appears to be Annex 2, no issue. But then when you read the judgment from 2015, they seem to say,
yes,
no, in certain circumstances, you require, even for exploratory drilling, particularly, I think it's particularly if it goes beyond 600 meters, you've got to have a mandatory EIA. So that's my confusion.
I know, yeah.
The European Court of Justice judgment is almost unreasonable.
I will just, if I may, just work through the directive first, and then we can go to the judgment. So Article 4, subparagraph 2, projects listed in Annex 2, member states shall determine whether the project shall be made subject to an assessment in accordance with Articles 5 through 10, and that is full EIA. Member states shall make that determination through a case-by-case examination or threshold set by the member state. So when a case-by-case examination is carried out or thresholds are set, the relevant criteria set out in Annex 3 shall be taken into account. And so those are the criteria that are then mirrored in the Domestic Act. So this is at the screening stage. This is during the preliminary, once the preliminary EIA application has been submitted. So even if we then go to the judgment and accepting the 2015 judgment on its terms, of course, we would accept that it is therefore a project listed in Annex 2, exploratory drills, and which member states are then left with a decision on whether to order a full EIA or just stop it at the preliminary EIA stage. So that's the key point. And that's why we say the process that was followed did not comply with the requirements of the FET standard in the treaty. But significantly, and it's not just process. It's also the question of whether the suggestion that the decisions had a significant effects on the environment had a rational foundation of fact. That's the key point. And so, if Slovakia was going to say, we think this drill in Smilno has significant effects on the environment, it needs to justify that by reference to facts and evidence. And none of those facts have been put forward by the other side, as was the case in Crystal X.
And where does it say that in the directive, though? Because the directive gives to the state the duty to determine whether to move to a full EIA.
Correct.
It then requires the full EIA to govern, I mean, it may be absurd, but to cover everything.
If an order for a full EIA has been made,
Right.
and that's the key point.
But which it has in this case.
But which we say they shouldn't have
Right.
done.
But
Yeah.
does the EIA directive of the European Union say you have to, at the case-by-case preliminary assessment stage, have to set out in that initial decision what your reasons are for going to a full?
See Article 4.3. When a case-by-case examination is carried out, all thresholds or criteria are set for the purposes of subparagraph 2. The relevant selection criteria in Annex 3 shall be taken into account. So that's at the preliminary stage.
Taken into account. It doesn't say, as someone who's just spent a long time on these wretched directives, it doesn't require you to specify particularly what the basis is in a particularized way. And the way that most countries work, including the United Kingdom, to say, we've decided we need to move to a full EIA, which is why the question that I have for you is, has Slovakia departed from its normal practice? In other words, are there other EIA preliminary decisions equivalent to the one from August 2017, which specify in great detail, and have they departed from their own practice in relation to this case? I don't know what the answer to that question is, but
I think what my response to that would be as follows. In relation to this aspect, measures 11 through 13, we are not complaining of a breach of national treatment. We're not saying that the process that was followed in this case in relation to these decisions was different from the process that was followed in other decisions. We are attacking the decisions themselves.
You're saying the decision lacks reason.
Exactly,
right?
exactly.
That's essentially what you're saying.
And also lacks a rational foundation of fact. That's the key.
Yeah, that is more difficult for us to see. If there are no reasons, you don't know what is behind the decision.
Well, exactly. And so therefore it was an arbitrary decision.
but arguing against that, on the other hand, you're going to have to address the fact that there were 174 statements somehow came in. Separately, some public bodies came in. Some of the public bodies said we have no problem with this project. Others said we have a problem with this project. And it's therefore possible for a reasonable reader to glean from that the decision maker must have been influenced by the totality of those submissions that were made.
We would accept that that is a reasonable inference, but we don't have time over a given time to go through the Kriva-Olka decision. But I would encourage you to read back through the reply at 165 through to 175, where we do undertake a comprehensive analysis of why the 174 decisions. In other words, what were the 3 concerns that were raised in the Krieger-Olke decision, and why those concerns didn't have a rational foundation of fact and weren't properly put forward in a manner that complied with the FET standard. So that's all I'll say. But it was those 3 measures which we say destroyed the economic and commercial viability of the project, as you see most closely from slides 147 to 148 of my opening, and that's the October 2017 minutes. And it was that full EIA process, see slide 138, that could have taken as long as 3 years. And that's the key point on the final nail in the coffin. Now, assuming that the tribunal concludes that the EIA decisions breached the FET standard, in other words, that those orders for a full EIA were not compliant with the treaty, the tribunal must then wipe out the consequences of that illegal act. So we then assume that in a but-for scenario, a full EIA would not have been ordered. Well, where does that leave Smilno? Well, the Smilno EIA decision was issued in August 2017. You'll recall that the interim injunction ended in May of 2017, Ms. Varianova's interim injunction. So the interim injunction would no longer have prevented AOG from entering onto the land plot. And we saw earlier in the comments submitted by the body of district office during this preliminary EIA proceedings, it was accepted that the proposed site is accessible using the field road. What's more, the district office deferred to the mayor and he raised no objection. And so based on those comments, we say that in a but-for scenario, it is inherently likely that AOG would have been able to use the road, the access land, to access the Smilno site. Now, Professor Sands, you pointed yesterday to Professor Stevchek's answer to your question. There are no clear answers to this question. Professor Stevchek was not conceding that the road was not a PSPR. His firm view, both in his expert reports and in Cross, was that this was a PSPR. Obviously, we accept the tribunal is entitled to examine that opinion, but significantly, this is not a case of rival expert opinions, because Slovakia's expert was not instructed to express any opinion on whether the road was a PSPR. And Dr. Fogas accepted that. This is transcript page 4, day 4, page 139, lines 18 to 24. See also the rejoinder appendix, page 4, footnote 8. So you won't find anything of assistance in Dr. Fogas's reports, and that's why I didn't ask him any questions about the road issue in Cross. So you are left with Professor Stevchek's opinion, which we say the tribunal should accept, and we say that this road was a PSPR. But my final argument here is, even if the tribunal doesn't accept that, in other words, even if the tribunal doesn't accept that the road was a PSPR, I would invite you to turn to the rejoinder at paragraph 575. And this is where I'm going to leave Smilno. It's internal page 17, PDF page 178.
Oh, PDF.
Yeah, hey, hard copy pagination 172, electronic page 178 of the rejoinder. Now, this is where they refer to our April 2017 press release. This is the community agreement C171. So paragraph 576. Discovery would undertake preliminary EIAs, and in exchange, the local citizens would stop protesting or otherwise stop seeking to block Discovery's project. And so the bargain that was reached with the local community in the press release was, you will undertake preliminary EIAs, and in exchange, we will stop blocking your project. So if the order for a full EIA had not been made, which we say in a but-for scenario, you should assume that it had not been made, then there would be no longer any blockages on the road. And if AOG couldn't have used the road as a PSPR, if you move forward, please, to paragraph 578, subparagraph A, over the page. this is Slovakia's own case, there would likely have been an agreement concerning the access land. So we say, in a but-for scenario, taking the 2017 community agreement on Slovakia's own case, the tribunal is entitled to assume that an agreement would have been reached on the ability to use that land. So even if AOG had not been able to use the road on the basis that it was a PSPR, this is what would have most likely happened, and that would have enabled AOG to drill its well. Now, if the tribunal agrees with that analysis, it does not need to decide whether impugned measures 1 through 7 in my table breached the FET standard. What the tribunal must do is ask what would have happened in a but-for scenario if the order for a full EIA at Smilno had not been made. And so we say the answer to that question is provided in Slovakia's own rejoinder. And so unless the tribunal would like me to address measures 1 through 7, I'm happy to do so if you have any questions or if you'd like me to. But that's where we would rest our case on Smilno.
I have a question going back to your saying the interim injunction was lifted in May 2017.
Yes, that's
And the preliminary decision, the decision for the EIA, for the full EIA was taken in August of
yes.
2017.
Yes.
And so if that decision had not been taken or had not ordered a full EIA, then the drilling could have started.
Correct.
From June on.
Exactly.
And by the fact that this decision was taken in August, that destroyed the project. Now, I have a causation issue there because once you start, when you have a drilling project, do you not always have to imagine that that may be an EIA that does delay you?
Sorry. So I think in terms of June, so we're not saying that drilling would have taken place started in June immediately after the.
No, but even if it was sometime during the 3 years that you're saying the EIA delayed the project.
Yes. Well, the point is, so the decision was issued in August, and that was when the order was made for the full EIA. If the tribunal is satisfied that that decision was a breach of the FET standards, then in a but-for scenario, you must wipe out the consequence of that decision. So
Yeah, and my question is, what are the consequences? The consequences are the cost of the delay. They're not the full project.
Well, the most important consequence, coming back to my legitimate expectation point, is the inability to drill the well. And
But
so,
not forever, for 3 years or the time of the EIA.
I'm being slow. Please forgive me. My basic point here is that if the order for a full EIA had not been made, then there was no other impediment to Discovery then being able to use the road to access the Kriva or the Smilno site to drill its well. And so in a but-for scenario, you would then assume that the well would have been drilled and that discoveries would have been made. That's the key point. And so on a damages point of view, that's the but-for scenario in which you're.
I don't have a problem with the but-for.
Yeah.
I have a problem with your
The
actual.
Yes.
Yeah, because what is the
Well,
damage caused by this decision in August, assuming it is.
I'm now with you. Please forgive me. It's been a long night. So the actual scenario in which Discovery found itself was then obviously a 3-year period where not only was it not able to undertake any drill at all, it was also required to then undergo the costs of a full EIA process, but most significantly, incurring overheads and continuing to pay license fees to the state during that period where it's not able to do any work. And so the point that was being made at the October 2017 meeting, the OCM meeting, this is slide, do you have the reference? This is, slides 147 and 148 of my opening. The point that was being made there as at October is we can't justify sitting on our hands for 3 years. It is not commercially viable to do so. And so that's the actual situation in which AOG found itself. And so that,
But you see that it is difficult on this basis to then justify damages for lost profits going forward.
but what we would say is, at the very least, it would justify. Do you mind if I just take one moment? And I just
Yeah, sure.
So the point I would make there on this is as follows. It wasn't obviously just Smilno. This was all 3 drilling sites. And so you have to look at the situation in which AOG found itself, having been prevented from drilling a well at Kriva Olka since early 2016, and then also now at Smilno. And the second point is, sorry, forgive me. But in terms of then how you then put that forward into damages, we would say that at the very least, there is a loss of opportunity to drill. That unquestionably exists. But if you're looking at damages on the basis of a market valuation, if Discovery had been able to undertake its drill at Smilno, it would be sitting on a license that had a value which you can derive from the market valuation. And that's the case also at Kriva Olka. And so that's how we say it ties together, and how we say the tribunal should obviously grant an award of damages in favor of Discovery.
Thank you.
One aspect you haven't mentioned, and it does relate also to this EIA issue, was, and it came up in, I think, exchanges in relation to the nature and extent, if any, of a full due diligence done before the investment was made and then in the course of the investment itself. I mean, there is some authority in the jurisprudence on which, to which you've made reference, that the legitimate expectation, it's not a sort of an absolute right. It's linked to other steps. And one of the steps is the extent to which a due diligence was or was not carried out. So we don't have any evidence before us as to a sort of formal legal due diligence. But if one homes in particularly on the issue of the EIA and that moment when a voluntary undertaking would have been entered into in the context of conversations with members of the local community, to submit yourself to a preliminary, should we call it EIA, one would have thought that a reasonable investor would turn their mind at that point to the risk that a voluntary preliminary EIA could morph into something more horrible, namely what actually happened.
Well,
and we don't seem to have before us any evidence, but I'm inviting you to say, yes, actually, there is that evidence, that the minds of the investors were turned to that possibility. In other words, you know, if I'm an investor and I enter into a voluntary agreement of that kind, I want to know what's the real risk, and I'm going to take certain steps to inform myself as to the possibility that this moves to the unfortunate next phase, which on your side it moved to. What steps were taken by the investor by way of due diligence to inform itself as to the risk of submitting itself to a voluntary preliminary EIA?
Professor Sens, obviously a lot of questions, but I will do my best to summarize, and I have a number of points I would like to make. The first point is that due diligence, as you quite rightly pointed out, has been said to be relevant to the content of the legitimate expectations standard protected under the FET provision and the BIT. But that question of due diligence is not relevant to the other strands, namely inconsistency and arbitrariness. So it's no defense to a state to say you should have undertaken more due diligence if the actual complaint is that the state has acted arbitrarily. That just doesn't work. And so we would say, to the extent that due diligence is relevant at all, it could only be relevant to legitimate expectations. So that's the first point I would make. but you,
But just on that, in relation to the arbitrary standard or discriminatory standard, at that particular moment that you are about to agree to a voluntary EIA process, I would have thought you ask yourselves the question, what is the possibility
and I'm going to
that it
take
could
you.
go into something worse?
Yeah.
What evidence is there that that question was asked?
Yeah, so so if we could go please to Mr. Fraser's first witness statement at paragraph 97. And you'll recall that I mentioned in the EIA application, they were professionally drawn up applications by a company called Kempro. Kempro were the agency that drafted those applications. So if we pull up Mr. Fraser's first witness statement at 97. Sorry, page 34, PDF page 34, paragraph 97. So he's talking, just wait for it to be pulled up.
When the first witness statement.
Yeah, so page 34. So if we scroll down, please, to the bottom. So he's talking in the third to last line on the 2nd of August, 2017.
Is this the first or second witness?
This is Mr. Fraser's first witness statement.
Fraser.
Yes. So on the 2nd of August 2017, the body of district office issued a decision ordering a full EIA in relation to the planned Smilno well. This decision came as a real surprise both to us and to Kempro. There were no distinguishing characteristics about the site from an environmental perspective that made it seem a suitable case for a full EIA, and Kempro had indicated to us, based on their experience, that they expected the application to go through without difficulty. The decision gave no grounds for its conclusions, which I understood it should have been done by law and found very strange. So the point there is that this was not a case where AOG submitted to this process expecting that a full EIA order would have been made. And that is reinforced, I would submit, by having regard to Minister Solomos's statement in January that when 8,000 exploration wells have been drilled and not a single environmental problem has been identified, that was a reasonable position to hold. So in my submission, it would be unfair to suggest that Discovery is in any way responsible for this. So that's where I would point the tribunal to on the question of due diligence. So unless the tribunal has any further questions, those were going to be my submissions.
Thank you very much. I think you had questions.
I haven't even begun. But fortunately, many of the questions that I had in mind to ask have already been discussed, answered either in your submissions or in your responses to my colleagues' questions. But let's stick with this for the moment, because I will go back to Smilno in a second. If we look at your slide that you pointed up, I think it's page 124. All right, the different boxes in the proceedings.
Yes.
Right. I understand, and you repeated this a couple of times, that the gravamen, as you said, later on you called it the key, were boxes 2 and 3, the proceedings and the decision that preceded the scope
Yes.
of the full EIA. So just clarify something for me, please. On the proceedings issue, because these are separate, arguably separate questions. Whether the district office conducted fair proceedings. Professor Sands asked you whether you can compare this to proceedings in other cases. I'm not asking that. I don't want there to be any suggestion that we don't have sufficient evidence on the record for you to answer these questions. Can you tell me where or in what manner the proceedings here may or may not have reflected the district office's obligations under an administrative code or a code of civil procedure or something like that?
I cannot give you an answer to that question now. We can obviously go away and
No.
in due course. But our key point
Yes.
is probably more of a forensic point, and it's this.
Let's hear.
And it goes back to again, disclosure. We asked for full disclosure of all internal documents that substantiated the orders for a full EIA by the district officers. And Slovakia voluntarily agreed to search for those documents, and not a single document came back. Now, we say that is rather telling. They confirmed no documents have been found. So the fact that there are no internal documents to substantiate this process, we say just reinforces the unfairness with which discovery was treated by the district officers during the so-called proceedings.
All right. Is that not rather a critique of the decision? The box 3, if you will, that I can more readily see from your submissions today
Yes.
and in the evidence before us. And in fact, I can more readily see that from the paragraph of Mr. Fraser's statement that you pointed out.
Yes.
You know, he speaks. Now, I'm not suggesting he should know the full details, but he speaks of a procedure whereby the application was published for comments.
Exactly.
Comments were received.
Yes.
I don't know if that's the idea is that is the full procedure required. But then, of course, the critique, and I think yours too, goes more to the decision itself.
Exactly.
All right.
Exactly.
That clarifies the point. Now, and of course, even if there was a proper proceeding, an unfair decision would still vitiate the
Precisely.
process.
Precisely.
But then you go on, even if that's the gravamen or key, but then you went on at some length today and in colloquy with Professor Sands to critique the box 1, 2, 3, 4.
Yes.
The imposition of the scope of the full EIA.
This is R193. Yeah.
Right,
Yeah.
exactly. And again, logically, I understand the point that even if everything up to box 4 was correct, that decision too would vitiate the entire process. Would you suggest, is that the case?
Well, we would certainly accept that. Yes. Yes. But the point is,
Well, I'm not arguing. I'm asking you whether that,
yes, we would maintain that. But the point, the key point we draw from R193
yes,
is that if these were the concerns or considerations which the district office was concerned by at box 3 or box 2, then in order to comply with the BIT and the FET standards, they needed to be put to AOG so that they could be addressed. And we say they would have been addressed because you only look at the Kempro document and you see why, for example, a suggestion about chemicals potentially causing pollution to groundwater would not be a valid complaint.
I think that takes us
Yeah.
back to the proceedings point.
Yes.
And I don't know what proceedings you're telling us are required. If the only thing required, I'm not suggesting this is the case, but if the only thing required is to receive the Kempro report, to publish it, to receive comments, and then to issue a decision, I don't see in that loop where there would be any further discussion
Well,
with the applicant and give the applicant an opportunity to address every concern raised before a decision is made. I wonder whether the
Yes.
answer might not be challenge the decision.
yeah, I can tell you this. I will find the reference short. My team will find this reference shortly. But during the Kriva-Olka EIA process, it followed obviously the same process. We have the application,
Yep.
it's published,
Yep.
and then we have various comments. The district office in that case invited AOG to respond to certain comments. And the point is that during that response, and you see it in the actual decision itself,
Yes.
so that we'll get
Thank
the
you.
exact document.
I thought I had seen something along those lines.
And so the
Very good.
point is that that did not happen at Smilno.
I understand.
And so that is our key complaint. If we can just,
So that's a distinction between the
Exactly.
Smilno EIA and the others.
exactly.
All right. The other two, the other one.
I think we explained in our memorial, if I
Yeah, if you
just,
could,
yeah,
Well, you know what? Let me continue. I've got other questions on other points, perhaps while your colleagues
sure.
come to the memorial paragraphs on that. Let me switch gears.
Oh, sorry, I can give you the exhibit reference
Oh,
now.
please.
Yeah, so it is exhibit C182, pages, as it's called, entitled AOG Submission to the Medzilla Bourse District Office, dated the 18th of December 2017. And that was AOG's comprehensive response to all of the objections that had been raised at Kriva Olka,
I see.
and explaining why each objection had no merit and wasn't, and that process wasn't followed in relation to Smilno.
Right.
Is there a requirement that it is followed?
you.
I'm trying
I
to
don't-
looking at this
That's
at
what I'm
the
looking.
EIA Act.
Yes.
And it doesn't really help me.
No, I mean, I haven't seen any, unless my team can correct me otherwise, I haven't seen any requirement that they, under domestic law, that they raise, give an applicant an opportunity to comment. But we would say that at the level of international law, in terms of the obligation of the state to act, follow a process that is fair, that at the very least, in order to comply with that obligation, an opportunity should have been given.
And here's an example of proceedings
Yes.
in the record, whether or not they, okay, very good. Right, let me switch gears. And come all the way back to Smilno. And you're very helpful. Slide 52, table of impugned measures. We don't have to look at the graphic, but I find it helpful. So here's a, I guess, a question of logic and legal reasoning. You impugn the actions of the police, the prosecutor, and the Ministry of the Interior, as well as the judiciary. What if the tribunal were to find against you in respect to the judiciary? What if, it's all hypothetical,
Yes.
you know how this goes.
Yes.
What if the tribunal were to determine, well, not only was there no breach of the treaty, but the judiciary effectively correctly articulated Slovak law?
Yes.
Would the other measures or the claims for breaches of the treaty by virtue of the acts of the police, the prosecutor, and the MOI fall away?
We completely accept that. And so,
It's a question, it's
yeah,
not,
no, and that is why I wanted to put my case in
Yeah.
closing, on the basis of
because
saying,
that's all on the basis of what the law is,
Well,
and
because the point is, the prosecutor was obviously talking about the injunction.
of course,
And of course, if the injunction was rightly granted, we're
Of
not
course,
going to suggest
course,
that it
very
was
good.
proper. But our key point on Smilno is that if you are with me in relation to the EIA aspect,
yes,
this is all in the past, and the tribunal doesn't need to concern
Precisely.
itself with measures 1 through 7.
precisely. Well, there you rejoin, that's a French one, but you join issue with one point that I recall being made by respondent in its written pleadings, is that by the time the EIA, the agreement to enter into
Yes.
the voluntary EIA arose, everything else was
Yeah.
water under, over the dam, under the bridge.
However you would like to put it.
Right.
But the point is, I think it's described by our friends as a fresh start. And if
Those are the words I.
and if the point, if you're with me on this
Yes.
way of expressing the case, we actually turn the respondent's case to our advantage and say, actually, this is what would have happened in a but-for scenario.
I fully understand that. Excuse me, I had a number of other questions, but I think they've been covered. If Madam President, if you'll give me a moment to look through my notes, I think that might be it. That's it.
Good. So thank you very much. It was a little longer than we
I apologize.
thought, but it was very helpful. So
Thank you.
suggest we take a 15-minute break now, and then we listen to the respondent. Good.
Members of the tribunal. On behalf of Slovakia, we'd like to begin by thanking you for such a well-run hearing and for the attention you've paid to this important matter. In our presentation today, I will provide the introduction, in which I will make some brief remarks about the 3 topics identified by the tribunal yesterday. And then we'll be going into each topic in some more detail. I will be handling Smilno. Mr. Pekash will then be addressing OLCA measures 8, 9, and 10 and the EIAs. First, the introduction. We have two preliminary points. First, what Discovery did this morning is the same thing that it did in its opening statement. You'll recall me saying in our opening statement that the strategy appears to be the following. When a fact does not fit within Discovery's narrative, it simply treats the fact as though it doesn't exist. It is not that Discovery has confronted the facts that contradict its case. It has simply ignored them. And so just as I did in the opening statement, Mr. Pekash and I today will again tell you the facts that are relevant but were not mentioned this morning. The second preliminary point is recall our opening statement and now just think about the evidence that you've heard over the past 4 days. That evidence confirmed everything that we told you in our opening statement. The evidence at the hearing thus far showed you that in its short time in Slovakia, AOG violated Slovak law, committed numerous legal errors, and showed a profound disregard for the very citizens that called this land their home. First, some preliminary remarks about Smilno. The PSPR theory was the central pillar to Discovery's case prior to this hearing. But the tribunal has now seen that it was indeed a private dispute between concerned citizens and AOG about private land. Smilno's mayor, who appeared before you, admitted that his view was the field track was not a PSPR, but instead a field track. Think about the importance of that admission. That is AOG's and Discovery's own witness, admitting that the central theory of their case is wrong. Indeed, as I told you in the opening statement, every state body that has been asked to consider the question of whether the track was a PSPR has rejected that theory. The district court rejected it. The Court of Appeals rejected it. The Ministry of Interior rejected it. The Traffic Directorate rejected it. And now, before you, members of the tribunal, the mayor told you that he rejected it. And so after 5 days of hearings, it is now undisputed that no state body ever adopted the central theme to Discovery's claim in this arbitration, that the field track was a PSPR. I want to talk, if I might, at the outset about an exchange between counsel and Mr. Dreimer. Mr. Dreimer, you had asked, very rightly, let's suppose that the court decisions are correct. What happens to all of the other acts that are complained about in measures 1 through 7?
You're giving me the opportunity to.
I apologize if I.
No, you did great. You did great. That's what I said, but I meant correct not only in Slovak law, pardon me, but also untainted by political pressure. Let's just be clear on that. Thank you. Go on.
The answer back was effectively that if those court decisions were correct, the injunction was lawful, then those acts are no longer challenged. Now, why is that so important? And this comes back to Professor Sand's question of Discovery's legal expert. The question was as follows. So if there are multiple opinions, I'm understanding you, sir, to be saying that there is a multitude of reasonable opinions that go in different directions. Am I correct in understanding you in that way? And the answer was yes, you do understand absolutely correctly. It is one of several questions to which there is no clear legal answer. Now, as I've already pointed out, every state body that ever considered the question came to the same conclusion, including the courts, which he had identified, and I'll point you to that testimony later, is the definitive view on what is the status of this road. But just pausing on the answer that Professor Sands asked and Discovery Global's legal experts' response to it, that reasonable minds could differ on this question. And then you combine that with this testimony. Professor Sands, are the judges on the appeals court independent? Answer, of course, coming from Discovery's own expert. Professor Sands, do you have any evidence that the judges on the appeals court decided as they did on the basis of any pressure brought upon them by the state? Answer, definitely, I have never in my life have heard anything like that, sir, no. Professor Sands, so your opinion would be, although the court got it wrong, the Court of Appeals got it wrong, it exercised independent and impartial judgment. Answer, no doubt, yes. In short, this means that Discovery's complaints about the courts, which is where Mr. Dreimer's question started with counsel, which are effectively denial of justice claims, cannot possibly meet the standards for a breach of public international law. That is to say, the testimony elicited by Professor Sands from Discovery's legal expert effectively said these judges were not under any improper pressure. They exercised independent judgment, but in his view, they got it wrong. Members of the tribunal, we all agree you are not a court of appeals that sits in review of lower court judgments on domestic law. And when we have the admission from Discovery's legal expert that reasonable minds may differ on this, a theory we don't need to adopt because we say all of the state decisions on this issue were uniform. But even if we were to grant that, coupled with his admission that there is nothing inappropriate about what the court did, aside from perhaps reaching the incorrect legal conclusion, it means it cannot possibly meet the standards of international law. And I'll come back to that in a moment, including reference to case law on how egregious a court error must be for it to rise to the level of a breach of public international law and equate to a denial of justice. Finally, as I'll discuss also in more detail, the hearing testimony confirmed that AOG did not seek, much less obtain, the social license from the local community before the critical period of time, that the protesters were not just one or two people, but rather a group of local citizens trying to defend their land, that AOG never obtained the permission required by Article 29 of the Geology Act to enter that land, that it violated the landowner's preemption rights when it purchased a 1/700th share, that a court issued a lawfully granted injunction prohibiting AOG from even accessing the site, that it then created a shell company to circumvent the injunction, that Mr. Crow faked his injury, that AOG waited almost 7 months to test its PSPR theory in court, and when the courts rejected that theory, never tried to access the site again. Preliminary remarks on Kriva Olka. In short, this claim is based on a legal mistake made by AOG. The ministry ultimately ruled in AOG's favor, and then AOG refused to participate further. The arguments we heard today were based on significant misrepresentations of the minister's testimony, and Mr. Pekash will point you to examples of that. It is undeniable that AOG failed to timely extend the lease. It is undisputed that AOG sent a new contract for signature to lessee, and lessee did not respond. And it remains undisputed that lessee's acts are not attributable to the state. The only thing the minister could have done was to deny the request for the extension, because there was no way for her to bring back a dead contract to life by quote unquote amending it. The testimony you heard during this hearing also confirmed that AOG then started an Article 29 compulsory process proceeding. During his examination, the minister explained that the first instance proceeding is run by the State Geological Administration. he is the appellate body, and that he never issued instructions regarding the first instance proceeding. It was a standard procedure taking place, and there was a separation of two levels of review. The testimony confirmed that AOG filed an appeal with the minister and won. During his testimony, the minister explained that as required by the Code of Administrative Procedure, he, as the appellate body, is assisted by a committee formed of prominent law professors and legal scholars in the field of administrative law. Again, standard practice. And that the minister, taking advice from that committee, ruled in AOG's favor. During his testimony, Discovery presented him with a new theory, that he should have engaged in fact-finding during the appeal and ruled definitively for AOG, so there was no remand. Well, although we were never presented with a fair opportunity to respond to that argument because it was only put to the witness during this hearing, the minister explained that it was standard practice. And of course, all of us familiar with courts of appeals know this. For a court of appeals, if it finds there to be a legal error and for further fact-finding to be required, to remand it to the body that typically does the fact-finding. In this case, the first instance body has the personnel necessary to do the fact-finding. And consistent with that standard practice, a legal error was found. It was not a factual error, it was a legal error. Further fact-finding was required. Now, what was that further fact-finding? Recall this is a compulsory process. It is a big deal for a state to require a private party to relinquish its right to keep others off their property. It is a remedy of last resort. So before the ministry is about to impose an order that forces private parties to relinquish their rights, it wants to know, is it really the case that we can't reach agreement here? That there can't be a new contract signed between AOG and lessee? And that's the factual issue on which he requires further investigation on remand. That is eminently reasonable. And that's exactly what the first instance body did. It asked AOG to furnish proof that it could not sign a new contract with lessee. And what did AOG do? They walked away. They walked away from the proceeding. They voluntarily refused to participate. Having appealed once in this process and having won the appeal, when the first instance body simply asks them, can you provide us some evidence that this really can't be resolved voluntarily before we do something that is a remedy of last resort? Rather than comply with that simple instruction, an eminently reasonable instruction there too, AOG voluntarily walks away. As for the memo that has received attention, the record now shows the memo was a draft. It was never made to the minister. The minister never saw it. And he categorically rejected that he gave any instruction. I would note also that we are the only party in this proceeding who has put forth a witness who was part of the Article 29 proceeding. Discovery has put forward no one. In short, I say what I said at the beginning. This claim, measures 8, 9, and 10, are based on a legal mistake made by AOG in not requesting the extension to the lease in a timely manner. The minister ultimately ruled in AOG's favor, and then AOG on remand refused to participate when it was asked to simply provide evidence that it couldn't voluntarily reach an agreement with lessee. Finally, the preliminary remarks on the EIAs. The whole point of a preliminary EIA is to determine whether a full one is necessary. We now know that AOG agreed voluntarily to do the preliminary EIAs. And there is no credible evidence that the state guaranteed that there would be no full EIA if they performed a preliminary one. So how could it possibly be that Discovery can say they had no legitimate expectation that AOG would have to perform full EIAs if that was the result of the preliminary EIA process? The
Didn't we hear
minister
today that their expectation was rather that the proceeding would be fair? and the result would be fair?
Yes, and Mr. Pekash will be addressing that in
Very good.
detail.
Because I also, maybe I dreamt this, but I think I heard a concession that of course, if that proceeding had fairly resulted in the need for a full EIA, that wouldn't be an issue.
We did hear that today,
All right.
I believe for the first time, but yes. The minister, to be clear, in his written testimony had stated and testified that he thought they had already started drilling prior to the 1st of January 2017. But when AOG applied for the EIAs, they stated in all three applications that the drilling activities would start only in the future. And that meant that all the drilling would have occurred after the Slovak legislation had been amended to require the preliminary EIAs even for exploration drilling. In other words, they knew that they needed preliminary EIAs for all three sites. And we also saw that this agreement to do the preliminary EIAs was not at an instruction from the minister. They had rejected that instruction. Instead, the agreement for the preliminary EIAs was based on AOG's efforts with local citizens as a way to try to obtain the social license that it never obtained from the start, and for them to stop their opposition to the drilling sites. Now, this is a key point that was not discussed this morning, but it's critically important. You heard AOG and Discovery complain about the decisions that full EIAs were required. But they could have appealed those decisions. And indeed, they did one. They appealed the Paruba site determination that a full EIA was required. I asked you rhetorically in my opening statement, I'll ask it again rhetorically now. Why, of all three sites, would that be the site for which you file the appeal on the full EIA? Paruba. The site where we're told they effectively concluded they had no real prospects. And again, what happened on appeal? AOG won. They did not even file appeals for the other two. Mr. Pekash will describe this in more detail later. But having decided not to appeal the decisions for full EIAs at the time, Discovery cannot come to you, members of the tribunal, and complain about them now. They have to give the legal system scope to operate. They had the ability to appeal these decisions if they thought they were wrong, if they thought the process wasn't fair, if they thought the conclusions that were reached were made up, but they didn't file those appeals.
Well, just to be clear on that, I mean, there isn't a requirement in the BIT to exhaust local remedies. I mean, if we take their argument on its face, if they considered that there was on its face a violation of the standard required by the BIT, I'm assuming it's not your case that they had an obligation to exhaust local remedies.
Go ahead.
Here I would point to the analysis in the Hellman versus Egypt case, and then the annulment of Hellman versus Egypt, which are very instructive on this point. The interpretation of the standard of FET and the scope of investment protections under the BIT, also other than the FET, was done at the level of the first decision in Hellman versus Egypt to say, to require the investor basically to first use appeals available within the administrative procedure and then bring the issue to the courts as well. The annulment committee then agreed with that only partially, and the annulment committee stated, yes, the investor must exhaust appeals available within the administrative procedure, not as a matter of exhaustion of local remedies, because the local remedies are the courts, but as a matter of, I would say, sufficient gravity, seriousness of the incorrect administrative decision. The reasoning is based on the fact that, as we know, a simple first instance administrative body may just get it wrong. That's why we have these appeals. And we need to give space, as Mr. Anway put it, to the administration system as a whole to operate. which also means that an issue needs to be brought to the upper levels of the administration, here the appellate administrative body.
But of course, you understand there are decisions that say otherwise, and how the administrative system is organized, and whether you have an appeal to an administrative body or to a court will depend from jurisdiction to jurisdiction. So I don't find this so convincing, frankly.
Well, this is not only in Helmand, it's also in EC versus the Czech Republic, which was very similar to the fact, in fact, that in the sense that the delays stemming from the multi-level administrative procedure were said to be the cause of the problem. I believe that if every single wrong administrative decision were supposed to engage international liability of the state, that would be excellent news for investment arbitration specialists.
But doesn't that go really to the point that the president raised in earlier exchanges? It's about the nature of the damage that is then recompensed. It may well be that if you go too early, the only cause of action that arises is in relation to the delay rather than the destruction of the entire investment. But the simple point I think you're hearing from the president and from me is, I think we would be, well, I'll speak for myself, reluctant to read into a BIT something that looks like an exhaustion of local remedies rule, when plainly the drafters of the treaty have not taken that step.
I respectfully disagree with that. I've been doing this for 22 years, and I can tell you.
If you've done it for as long or longer.
And I believe that the distinction between exhaustion of local remedies in the sense of court intervention and the operation of the administrative system as a whole is a well-established one. Obviously, there being no Supreme Court of Investment Arbitration, I am well aware of the fact that the case law may be divergent on this and other issues.
But that is, and of course, we would never suggest we have any more experience than the arbitrators, as we understand the tribunal is even more experienced. But the analogy, of course, is to the court system, where you would not find an exhaustion of local remedies requirement in the treaty either. But nevertheless, it is very well accepted, as the tribunal members know, that when you have a claim for a denial of justice, it is expected that the party at least avail itself of the appellate options that are present. And the analogy here to the administrative system, where you similarly have appeals that are available to correct lower body errors if they exist, we think is an apt one.
Yes, but of course, denial of justice is precisely the exception that confirms the rule about exhaustion of
We understand.
remedies.
In short, with respect to the EIAs, there was no retroactivity. There was no conflict with any legitimate expectations. And this cannot be, in our view, a violation of the treaty, because they complain of first instance administrative decisions, which they could have won, which they could have made. In 2 instances did not do so, and in the one they did appeal, they actually prevailed. Now, let me move on to Smilno in particular. I'd like to start with an exchange between Professor Sands and opposing counsel during the opening statement. This is day 1, page 28, lines 14 to 24, and it's over this critical issue of what due diligence AOG made with respect to Smilno. And in response to Professor Sands' question, counsel stated, quote, "Of course, we can't point to a legal opinion that has been produced in this arbitration which confirms at the time that the road was a public road. In addition to the due diligence that should have been performed, discovery should have expected that people may oppose its activity on their land. You now, members of the tribunal, have heard from and seen some of those local citizens. Ms. Varyanova, when she asked about whether she agreed with a description of activists, said, "I feel like a citizen, not like an activist." You'll remember that testimony. You saw how credible she was. These were not made-up concerns. This was a landowner trying to protect her land and her environment. You also heard from Mr. Leschko. Again, I told you during our opening statement, we were not here to represent these private citizens, but we wanted you to hear their story from them directly. And now you have had the opportunity to do so. And that's day 3, page 226, lines 6 through 14.
Remind me, please, why, other than the very understandable opportunity to give these citizens, leading members of their communities, a chance to speak, why is it important to your case that we find them credible and their evidence to be accepted?
With respect to the social license that we say should have been obtained and never was even sought to be obtained,
Very good.
among other reasons.
Thank you. And well, later on, I'll ask you where that fits into your defense, but
Yeah.
thank you.
We trust that their testimony showed that they were not the only local citizens who protested, that their concerns were understandable, and that AOG did not obtain the social license with them prior to the critical period of time. The testimony of Mr. Frazier confirmed that an injunction was issued that prohibited AOG from even accessing the site, and that it was his understanding that AOG was not permitted under law to access the site. His testimony also confirmed that AOG created a shell company, Smilno Roads, to circumvent that lawfully issued court injunction. And that despite the injunction, AOG, using that shell company, in fact, accessed the site repeatedly, modified the road without landowner permission or a permit, and in violation of the injunction, and in fact moved the road. It's easy, I think, to get lost in the minutia of the case and forget that. That, as we pointed out on slide 110 of our opening, that timeline, throughout the critical time period in this arbitration at Smilno, AOG was repeatedly violating that injunction. You'll see on that timeline 8 different instances where it violated the court-issued injunction. In other words, for the vast majority of time that's relevant here for Smilno, AOG was an open violation of Slovak law. We learned during the testimony from the hearing that Mr. Crow said he was willing to come testify as a witness in this arbitration. And according to Mr. Lewis, he certainly wasn't prohibiting him from doing so. You may ask yourselves, members of the tribunal, as we did, then why isn't Mr. Crow here? We were criticized quite heavily this morning for not making certain people witnesses in this arbitration. Quote, it would have been the simplest thing in the world for Slovakia to produce a witness statement from Mr. Harvel. That's 11/12/12 from this morning. We find that an interesting comment to make when they're putting forward fictitious evidence of a particular individual. They're caught in that, and neither in the memorial with that fictitious evidence, nor in the reply when they had the opportunity to respond, put any witness statement in from Mr. Crow. It's confirmed by Mr. Frazier's testimony that after this faked injury, AOG pressed the police to arrest one of the local citizens for it. They criticized the police for not arresting the local citizens for it. Thankfully, the police didn't arrest someone on false charges, and yet again acted appropriately. We were criticized quite heavily this morning about missing documents. Again, a very interesting charge, given that we only found out in the middle of the hearing about the attachment to AOG's letter to the mayor, which turned out to be so important.
You also heard that it was an honest mistake. I don't know whether you accept that, but I think that's what I heard, that it was intended to be translated and somewhere in the process it slipped through the cracks.
Yes, I recall that. What about the prosecutor? You saw the prosecutor testify. You saw how credible she was. She came to the site not because the local citizens called her, as had previously been suggested, but because AOG had called the police and the police in turn called the prosecutor. She testifies that when she arrived at the site, she was told the injunction didn't apply to them. We now know that to be a false representation. And she determined that this was a civil dispute rather than a criminal one and left the site. What about the mayor? Let's be clear that none of the impugned measures rely on the mayor's conduct. But the mayor confirmed, their own witness, that the field track was not a PSPR, the central theme to their case. And in fact, was only a field track, day 3, page 72. What about the courts? There was some discussion during the hearing, again for the first time, that the action that was brought by AOG for an injunction and the court's decision of it was somehow improper. But those aren't part of the impugned measures either. Remember, that court decision you were never even told about in the memorial. Discovery didn't even inform the tribunal that they had tested their PSPR theory before the Slovak courts, and that both courts that had an opportunity to address that theory had rejected it. And as I said earlier, we have Discovery's legal expert who believes, and we don't accept this proposition, but states that on the issue of the PSPR, it is one of several questions, quote, to which there is no legal answer. And now I come to the denial of justice cases. What must be necessary for a court's decision, a domestic court's decision, to violate international law? This is cited in our counter memorial paragraph 356, citing a variety of different cases, which you can find in footnote 479. Quote, the international dialect of denial of justice is subject to a particularly high threshold. It only sanctions a systematic and flagrant failure of the host state's judiciary to grant due process to the investor, and is only available where the investor has exhausted all available local remedies. Another cite from paragraph 363 from our counter memorial, citing the Iberdrola versus Guatemala case, quote, denial of justice is not a mere error in interpretation of local law, but an error that no merely competent judge could have committed, and that shows that a minimally adequate system of justice has not been provided. Or in Yandanal, absent proof of discrimination or severe impropriety, an international tribunal cannot review the scope of jurisdiction of domestic courts or their application of national law. When you take that authority and you put it next to their own legal experts' conclusion that this was an issue on which legal minds could differ, as well as the admission that there was no improper pressure put on the court and that they were exercising independent judgment, it shows you that the criticisms of the courts that you've heard in relation to Smilno don't come remotely close to breaching public international law. And so in sum on Smilno, no due diligence, not engaging with activists to get a social license, antagonizing them by going on their land to physically remove their automobiles, bombard the car with concrete cement blocks so they can't move them, creating a shell company to circumvent a lawfully issued court injunction, faking an injury and trying to have the local citizens prosecuted for it. And 2 court decisions that found the PSPR theory to be invalid, together with every other state official that had analyzed the question and was asked to give an opinion about it. In conclusion, in the short time in Smilno, AOG, as I said, violated Slovak law, committed legal errors, and showed a profound disregard for the very citizens that called this land their home. We respectfully submit that Discovery's claim, and particularly establishing that the court decisions, coming back to the exchange between Mr. Dreimer and counsel this morning, if those decisions are correct, if that injunction was lawful, all of those other measures fall away. And we would respectfully submit that it has been established that claims 1 through 7 now are no longer viable. Before I turn it over, with your leave, Madam President, to Mr. Pekash, there's one other issue that came out yesterday during the testimony that I would ask Mr. Palawa to address very briefly, just to correct something that I think may have caused confusion with the tribunal. Thank you.
Thank you, Madam President. So if you'll recall, at the end of Mr. Duarte Silva's testimony and Mr. Aklam's testimony, you asked them about the royalty with respect to sunk costs and whether they contested the royalty. And they didn't mention it in their expert reports, but we contested it, and we contested it in our rejoinder. And I can point you to the paragraph and just give a brief explanation why, but it's paragraph 725 of our rejoinder. And the reason why we contest it as a sunk cost is because Discovery Global, or AOG, never paid £120,000 for that royalty. It was purchased by a company called Alpha Exploration, which is another company of Mr. Lewis's, and then transferred to Discovery Global for nominal consideration of $10. And you can find that at C84. And so we do contest that in the sunk cost calculations. Thank you.
And it's not to say our submission was that the expert was wrong, just that the expert was not asked to consider that.
Members of the tribunal, I will now address you specifically on the Kriva Olka alleged violations of the BIT and the EIA related alleged violations of the BIT. But before doing so, I would like to respond to a point which was put to us in the closing statement of the claimant, stating that we did not really engage with their arguments on legitimate expectations. In fact, I believe we did. What I would like to point out here, and frankly, that's a repetition of something that I stated already in our opening statement. There is a significant misconception on the part of the claimant with respect to how legitimate expectations operate and how they operate specifically in our case. I believe that it is undisputed that legitimate expectations have to be based on specific assurances provided by persons which have the authority to provide such assurances. A very good discussion of these various categories of assurances which may be provided is to be found in, I believe, Continental versus Argentina. It is, I believe, undisputed that these assurances must be provided before or at the time of investment, and therefore, to put it differently, the alleged legitimate expectations must be investment backed. What is a consequence of just this temporal rule? The consequence of this temporal rule is that the only source of potential legitimate expectations in the present case can be, as it was, I believe, admitted this morning, the exploration licenses and potentially assurances provided at the time or before Discovery's acquisition of AOG in 2014. This morning, we haven't heard anything about any such assurances given at that time. The practical and very important consequence is that Discovery cannot base its alleged legitimate expectations, for example, on the press releases of the Ministry of Environment and Minister Solimos, which were issued at the end of 2016 and in the first parts of 2017, because this is well after the time of Discovery's investment. Now going back to the one document that could in theory be a source of legitimate expectations, this is the exploration licenses which AOG had at the time when it was bought by Discovery. Here, the problem with claimant's case is that they derive from that document alleged expectations which actually do not stem from the text of the document. The exploration licenses are licenses for exploration of a very large area in eastern Slovakia. We saw that actually on maps, both during the opening statements and then later during cross-examination of the industry experts. We submit there is no basis in the text of these licenses for the contention that somehow Slovakia, by issuing these licenses, committed to approve just any single location for an exploration drill that would be located within the licensed areas. The licenses simply do not state that. What the license, however, does state specifically is that the activities will need to be conducted in accordance with Slovak law. Therefore, the license is just one of several approvals and legal arrangements which are required for AOG to be able to conduct an exploratory drill on a specific location somewhere in the licensed area. And the licenses themselves do not say anything about a guarantee that the additional hurdles will be cleared so that a drill can be put on a specific location within the licensed area. And these additional hurdles are twofold. First, there is the requirement for the investor to obtain a private law title to the land plot on which the exploratory drilling is supposed to take place, and where and when necessary to obtain private law title to access that land plot if the land plot is not accessible from a communication subject to the general use of such character that even the heavy machinery needed for the exploratory drilling could be brought to the site on that communication, relying on the general use of that communication. A very minor point, which, however, illustrates the issue, was heard during the cross-examination of the mayor of Smilno, Mr. Baran. I asked him a few questions about the quartz mine, which used to be there. And during that time, Mr. Baran stated not only that the quartz mine had shut down shortly after World War II, but also that the owner of the quartz mine actually had been leasing access to the mine from the owners of the road, which actually is a very valuable testimony because it confirms that in the past, the use of the road was subject to the consent of the owners. And that the owner of the mine actually did obtain this private law consent, and that's why the owner was able to use the road. So this is the first category of issues that AOG needed to address when placing an exploratory drill somewhere, to make sure that they have the private law consent of the owners to do so. The second category of issues is the compliance with public interest. Public interest here means not only public interest as it may be formulated by various administrative bodies, but also public interest as formulated by the citizens, which then have the right to voice their concerns as a part of administrative procedures conducted by the administrative authorities. And obviously then there are rules under Slovak law how these concerns need to be addressed in a process which then leads to a final decision resulting in an administrative approval or the lack of approval for the location of a certain site at a specific location. I just thought that it will be important to highlight that nothing in the text of the exploratory licenses suggests that this process was to be skipped or derogated from when it came to the placement of specific drilling wells at specific locations. And actually this morning we heard an admission that Discovery does not claim there was any sort of stabilization clause included in the license. That becomes relevant with respect to the EIA. But before turning to the
Do you agree at least with the proposition broadly stated as it was by claimant, both by counsel, both in his opening and in his remarks today, that at the very least, the licenses demonstrate or reveal a quid pro quo? We will conduct ourselves in accordance with the rights and obligations imposed upon us. And in exchange, the state will not prevent us from engaging in the works that we are required, in which we are required to engage under the licenses.
it depends on what is understood by the state preventing.
Well, that's,
If the negative decision is issued as a result of the states weighing the competing public interests or the interests of the public, then this is not covered. We would accept that, yes, the state would not prevent arbitrarily or just because the state had second thoughts and now thinks that it's not a good idea. I would say for economic reasons, for example, to conduct exploration in the areas.
Okay. I presume you'd say that doesn't arise necessarily or strictly under the licenses themselves, but this as a general proposition. The state's
I would agree with that.
responsibilities.
I would I would say without the state issuing a license for a certain area, then the state could say in the future that this area is restricted for exploration and that it would not violate anything. But having issued a license, the state is not supposed to do that.
Thank you.
So that opening now brings me to what happened specifically with Kriva Orka. Actually, we all agree that that an issue which probably would have been easily preventable by Discovery if only they had sent a request for extension on time. But they didn't. So Discovery had a lease agreement with LLC. They were supposed to ask for its extension by the 16th of December, 2016. Oh, sorry, 15. And they didn't. They sent the request 7 days late on the 23rd of December, 2015. LLC agreed with the extension in an extension agreement, which is actually has the legal form of an amendment to the original lease agreement. And LLC signed this amendment on 14 January 2016. And now if we please look at this document, which is document C-116. And we go to final provisions. Thank you. So we can scroll down, please. Yeah, and it's Roman 2 final provisions, Arabic 3. This addendum enters into force on the date of granting consent to rent according to Article 50, paragraph 7 of Act on the National Council of the Slovak Republic on forests, and effective on the day following its publication on the Central Register of Contracts based on Act number 546/2010 collection. And that then, in combination with Slovak civil law, creates the problem and exactly the kind of situation which the requirement to apply for an extension 30 days before expiry was supposed to prevent. Because this amendment is then sent to the Ministry of Agriculture on the following day, January 15, which also happens to be the last day of validity of the original lease agreement. And therefore, if, let's say, on January 16, the Ministry of Agriculture looks at this amendment, it sees that the amendment itself is not in legal force, because the amendment will enter into legal force only on the day when the ministry approves it. And because we are already on January 16, we have the problem which stems under civil law in Slovakia and then has not been disproved by discovery in any way, that the civil law of Slovakia does not make it possible to extend the validity of an agreement after the expiry of that agreement. So what happened on January 15 is that the original agreement expired in accordance with its own terms. There was an addendum signed seeking to extend the original term, but the addendum was not yet in legal force. As a result, it did not produce any effects and did not prevent the expiry of the original agreement, which then had the consequence that the Ministry of Agriculture, now being bound by Slovak civil law, could not grant its consent and thereby bring, well, it could have, but it would have had no legal effect because as of January 16, the original agreement expired. A consent granted, let's say at the end of January, would have made this amendment enter into legal force, but the extension sought by this amendment would have been invalid because that would have been an extension done retroactively. The legal force of the extension would have been January 30th. That is 2 weeks after the expiry of the original lease agreement, and this is not possible under Slovak civil law.
You're saying that the lease had already expired by the time the amendment crossed the minister's desk?
The lease expired on the same day when this amendment was forwarded to the Ministry of Agriculture.
So it wasn't yet expired.
Well, it was the same now. It was the same date. We would need to see when exactly
Yeah,
it
of
ended
course.
up on the
Alright.
minister's desk. But I would say that in any event, it's not reasonable to expect the minister just to take the letter the day it arrives and approve it immediately.
I take the point. I'm just trying to get the
Yeah.
chronology down.
Yeah. So this is what created the problem. On 17 January 2016, AOG sent a letter directly to the Minister of Agriculture, where AOG requested that the minister approve the extension. So that was after the expiry of the original lease agreement. And AOG also stated that if the extension is not approved, AOG will be entitled to make an application under Article 29 of the Geology Act. That this letter is just for reference, this is C-118. Then on 18 July 2016, AOG applied with LLC for a new lease. This is the letter that you saw this morning, because in the letter, AOG conceded that it was not legally possible to extend an expired contract, as I explained it a while ago. And AOG required in that letter another lease agreement for a definite period of time of approximately 1 year until the 1st of August 2017. Lessee did not reply to this request. However, it is not alleged that this lack of reply violated the BIT, as I think it is conceded that the conduct of lessee is not attributable to the Slovak Republic. So then what happened is that AOG initiated the Article 29 proceedings, which is a measure of last resort, if I may call it that way, which allows the Ministry of Environment to overrule the lack of consent or silence of the owner and grant access to the site and use of the site itself to an entity conducting exploration under the Geology Act. You heard Minister Solimos explaining how that procedure was conducted at the ministry. One thing I would like to highlight here is that, and it was not only in connection with the conduct of the Ministry of Environment, but also in connection with the conduct of the Ministry of Agriculture, we were, if I put it bluntly, accused of withholding documents. That accusation assumes many things about how the Slovak ministries are archiving documents. It assumes a lot about what documents actually are archived, for how long the archives have to be maintained, etc. Actually, none of this was discussed by Discovery. All we heard is, oh, yeah, certainly there must be many more documents. And we believe that Discovery actually has the burden of proof to show that there is some basis under Slovak administrative law for their contention that when they made their document requests in this arbitration in 2023, the Slovak Republic was still required to have documents such as emails exchanged between Mrs. Matejová and Mrs. Janova. There should be some basis also for saying that Mrs. Matejová and Mrs. Janova were supposed to communicate by email and not just orally when they meet each other. There's no basis for the contention that somehow the meetings that the Minister of Environment had on a weekly basis with the heads of the various sections were supposed to be recorded in minutes. There was no explanation with respect to the level of detail that these minutes were required to offer. And there was, again, no explanation for the contention that somehow these minutes should be available, 6 years later on the systems of the ministry. Another suggestion of this type was that the files of the ministry were supposed to have initial drafts of any decisions, drafts of the alleged instruction from the above to decide in a certain way. So I would like to rectify that. All that a ministry or any other administrative body in Slovakia is supposed to do with respect to an administrative decision-making process is to archive documents in what is called the administrative file. The administrative file, and that is very important because you this morning heard about a reference to a specific file number, which I don't have here, but I will find it and give it to you. That was basically the file regarding the Article 29 procedure. So all documents in the file are at any moment available to any participant in the proceeding. So here, if the file, if the procedure deals with AOG's application for access under Article 29, it means that AOG may at any time ask the ministry to show it the file, and AOG is entitled to see the entire content of the file. And the ministry actually has an obligation to put all relevant documents into the file. So there's no like, two separate storage systems, one, the file, and then, something for internal use only. That does not exist under Slovak law. And the same then holds true for the EIA procedures, which were conducted by the district offices in Eastern Slovakia. The same principle. Again, the district office takes all documents which are relevant and puts all these relevant documents in the file. And AOG as a participant in the proceedings, because it was also the applicant in the EIA procedures, can access that file at any moment. Not only during the time when the file is live, so to say, but also thereafter for as long as the file is archived. And so the reason why we did not produce any documents in response to some of the document requests is that we simply stated the documents are available for you to in these files. Just please go and get access to them in those files. And there was no order by the tribunal that we are required to produce again documents which are accessible to discovery in the administrative files. We do not even know if discovery went there or not, because these files are decentralized at the level, but there was no objection raised against this method of access to documents at the time. So we consider it unfair now to use it against us, the fact that there was like no documents exchanged with respect or produced in response to some document requests, if we believe there was an understanding that these can be accessed in the files to which AOG was a participant. So this is to rectify one misconception. Another misconception, or I would say distortion of the witness testimony of Minister Solimos, is that I heard this morning that Minister Solimos somehow admitted this was a sensitive procedure. Members of the tribunal will recall certainly that the sensitivity comments of the minister related precisely to the nature of the interference of the state with the rights of the owner of the site. He was very careful to explain that he considers Article 29 procedures to be sensitive because they restrict the rights of the owners of the site and access land by a decision of the ministry, which actually forces the owner to let exploratory works be done on their land. And another comment of that type related to Minister Solimos responding to a question asked by Madam President about whether he interferes with proceedings which are handled by the lower sections of the ministry as organs of first instance. And his answer was no. Then he added usually, and that's where the quote stopped. But actually there's a further line. Madam President asked specifically what the usually meant, and Minister Solimos explained that he did not interfere categorically. So there was no, like, this usually was rectified or clarified upon Madam President's follow-up question. So what happened at the ministry then is that there was a first instance decision issued, which roughly speaking denied jurisdiction, saying that this matter is not to be decided by the ministry because the ministry would interfere with the jurisdiction of the Ministry of Agriculture, which was supposed to approve or not approve the lease with Lassie. That decision was appealed by AOG. And it was then decided by the minister. The appeal was decided by the minister. So 2 points here. First, we heard today again about this alleged decision coming from the above for the first instance decision to be negative, as I described it. There is no evidence for such instruction to be given. It was vehemently denied several times by Minister Solimos when the point was put to him during his cross-examination. One thing which is very important again is to rectify the point about when Minister Solimos was told by us, Council for Slovakia, about the allegation. Point was made that this was done only in connection with his second witness statement as he testified on Saturday. Indeed, this is factually correct, but the reason for us doing so is that the memorial did not tie the instruction to Minister Solimos. We did not, the allegation that it was Minister Solimos himself who issued that instruction was voiced for the first time in the reply. And having read that in the reply, we brought it to his attention when preparing his second witness statement, which was filed together with our rejoinder. So now we have seen that that has become the preferred interpretation of what happened, but this is incorrect. Minister Solimos denied giving any instruction very clearly and repeatedly. I believe that we also clarified the issue of the information for the minister and the privilege log. In my opinion, it is absolutely clear from Minister Solimos's testimony that he did not see that document at the time, and this is consistent with what we understand happened. Minister Solimos was not presented that document when preparing for his witness statement. He also explained that. So now we are before the minister, and the minister has to decide on the appeal which was filed. Mr. Anway explained that the minister has what the law calls a special commission, but in fact it's not a special commission in the sense of an ad hoc commission. It's a commission which is set by the minister, and it's set by the ministers in all ministries in Slovakia to deal precisely with this very special appeal which can be filed against the first instance decision made by the ministry. In the Slovak language, actually, it's not even called an appeal, but uses some different word than appeal, which is impossible to translate into English. So that sometimes leads to confusion. But that's why it was called on interpretation. Sometimes you heard the expression appellate commission. So that's how these are normally referred to. They are, as Mr. Anway explained, they comprise prominent specialists in the field of administrative law. The reality is that ministers always follow the recommendations of the appellate commissions simply because the minister obviously has no specific education in the field of administrative law, and if such an knowledgeable commission recommends something, the minister does not decide not to follow the recommendation. There's always an exception to the rule. The ECE case was all about the minister actually not following the recommendation of the commission in that one case, but it was a different minister in a different country. The minister, in theory, has the possibility to decide, so basically rectify the first instance decision and issue the decision. In practice, the minister always remands the case back if unless the decision can be confirmed. This is what the minister, I think, also confirmed during his cross-examination, that he either confirms the decision or quashes the decision and remands it back.
Remind me, please, if you can, without pulling up the document, the recommendation from the special commission or appellate commission was not only to quash, but to remand as well. Is
Yes.
that right?
That's right. I'm not sure we have the document on the record.
No,
but
but
Minister
it's
Scholimosh.
quoted in the minister's decision.
Exactly, yes. And I believe on
Am I recalling
cross-examination,
correctly as far as your?
I recall him
We
giving
can, we'll
testimony
look it
to
up
that
in the
effect, yeah.
evidence. We don't need it now. But I seem
Okay.
to recall that the at least as quoted in the minister's decision, his commission had said not only quash, but quash and remand.
Yes, it's actually impossible for the minister to quash without remanding.
That's true. Of course. All right, but very good. Thank you.
But this does not mean that the minister said nothing about the further course of proceedings, because the minister, so the question which was submitted to the minister was fundamentally a jurisdictional question. Was it right to say that the Ministry of Environment doesn't have jurisdiction, or was it not right to say that they do not have jurisdiction? And the minister says very clearly that no, the ministry has jurisdiction and has to decide the request. And that's very important, because that means that the minister was not just, seeking to somehow make the procedure last longer and cause any delays. What the minister did is that he confirmed, no, the ministry has jurisdiction, but now the ministry needs to engage in additional fact-finding to see that whether the Article 29 procedure is really to be used, it being the procedure of last resort, and there's no possibility for AOG to reach agreement with lessee. The absence of such agreement being precondition for granting the request under Article 29. And so what the ministry then did when the file returned to the section of geology, which was handling this request, is to follow exactly what the minister had suggested. They asked AOG to clarify this factual point. And at the same time, they suspended the procedure. The suspension of procedure at the time when some information is requested from the applicant is absolutely standard practice, because the administrative authority has a time deadline for them to issue the decision. Obviously, they do not want to miss the deadline just because the applicant takes too long to supply information which was requested. If you remember, I asked some questions from Minister Scholimosh upon my redirect. It was very clear from the text of the decision that first there's the decision to suspend. First there is a reference to the request for information. Then there is the decision to suspend. And then there's the sentence saying that, as soon as it's called in the administrative jargon, the obstacle to further conduct of the proceeding, but that's actually means you need to provide the information. As soon as we receive the information, the procedure will resume, and it will resume on its own. All that AOG was required to do at the time was to write to lessee and either get a negative answer. Obviously, if they had gotten positive answer, the entire Article 29 procedure would have become redundant. We asked for, but didn't get an extension of our contract, or sorry, an extension, a new lease agreement with lessee. AOG did not do that. AOG basically said, there's no way we will ask we will ask lessee again. And now we submit that to explain this sudden inactivity on the part of AOG, we need to look at where we are in time. So the refusal came in a document dated on the funding side of AOG. So we know that AOG had already run out of money in January of 2017. So we are now in July, 7 months later. And at this point, Discovery was trying, but failing to secure new finance. '98. It's an email to Cadogan where Mr. Fraser noted that Cadogan wanted more data. And this comes at a time when AOG was so low on funds at that time that it proposed selling physical materials to cover short-term cash needs. That stems from document C 376. That's a letter from Michael Lewis dated 26 July 2017. And we respectfully submit that this is the reason why the Kriva Olka Article 29 application was abandoned. So what happened is that on 27 November 2017, AOG complained to the minister for alleged inactivity of the first instance body. That's document C 384. And the minister rejected its complaint, AOG's complaint, on 31st January 2018, stating that the Article 29 procedure is a proceeding initiated upon the application of the applicant, AOG, and that it had been suspended for AOG to provide factual information, which AOG had not provided. So if there was any reason not to, well, the only reason why the procedure was not proceeding was AOG's refusal to provide the requested information or to show that lessee did not answer to a new request for a lease agreement.
I am told by the secretary that you have spent 1 hour. Bit more.
Yeah, so I will now move to the EIA.
I agree that the claimants was much longer, but they were much more interrupted, and I hope that the secretary does interrupt each time we have a question. So we only counted the actual presentation time.
And so what was then the actual?
Yes.
How much time did the claimant use if you deduct the time of
1 hour.
1 hour?
Mhm.
And
Okay,
mean,
apologies,
we're
that
not-
was-
12:40.
we will not cut you off on the spot, of course, but
Okay.
you know that your time is.
Okay, I was under the impression that it lasted longer, but yes, there were many questions from the tribunal,
Yeah,
which.
yeah,
sort of,
we're trying to be
changed the-
fair and really deduct answers and questions and answers to questions.
Okay, so anyway, just to finish on Kriva Olka, the procedure was abandoned in summer 2017, and we submit that was because of the financial difficulties and lack of funding on the part of AOG. And the abandonment went through
I think
AOG's
we
refusal
we
to.
got.
Yeah, you got that,
part.
perfect. Yeah, okay, so now moving to the EIAs.
And try to be.
Yes, I will be very brief there, actually. So number one, we keep referring to them as voluntary EIAs, but in reality, they were not entirely voluntary. because there had been no drilling prior to the 1st of January 2017. So on proper application of the EIA amendment, Discovery or AOG actually had an obligation to undergo the EIA process. And if there were any doubts about that, they were completely dispelled by AOG's EIA applications, which were all filed in 2017. And all of them stated that drilling would only start at a later date. So this is actually very important to now see the psychology of AOG, because AOG is making this big concession in their discussions with the local community by saying, oh, we will do that voluntarily. But in fact, they only do something which they would have had to do in any event because of the factual situation on the
No,
site.
I think we understand that part.
Second, there are some statements by Minister Solimos which are not accurate, because as he explained upon cross-examination, actually, he had been led to believe that the drilling had started at the sites. And the reason for it is the meeting with AOG that he had on 15th of December 2016, and a presentation which was brought to that meeting, and which, as I said, led him to believe that the works were already underway. In reality, there was nothing underway in Ruska Poruba, nothing underway in Kriva Orka, that's not even undisputed. And the only thing in Smilno was the 21-meter deep collector hole, which is not drilling.
I think in the interest of time, I think we are aware of
Okay,
this,
of the factual,
and
yeah.
we will
So now we
review
can
the
go just to what
evidence in due
was
time.
mentioned now. What was proposed this morning actually is a total confusion between preliminary EIA and the full EIA. The proposal was that the BIT somehow requires Slovak administrative organs to assess not the existence of risk, but engage into an actual discussion of the impacts at the stage of the preliminary EIA. What happened during the preliminary EIA procedures is that they were tense, and in one case, more than 100 concerns voiced by the general public about various environmental problems with each of the sites. We submit that in that situation, the first instance organ had frankly no other way than to order a full EIA.
I think you could help us by telling us where it states what the first instance must do, because I imagine that each time you do a preliminary EIA, there's at least one person who has a concern. Does that mean that each time you have to go to a full EIA, or do you do some kind of assessment, and what?
Yeah, so I would submit that this is.
And the
actually-
other question, sorry, is do you have to give reasons? Because I think that was one of the points that your opponents made.
Yeah, so reasons have to be given, but it's also okay to just refer to another, not another document, but to, for example, refer to the concerns raised by one of the participants. If the concerns are summarized in the decision, the authority does not need to spend another page or two. It's enough for them to just say, as they did it actually in this case, in light of the concerns raised. That means the concerns, however, have to be listed in the decision, and they were. So this is a very, very short but sufficient justification as required under Slovak administrative law.
That's the reasons. What about the process? Remember, 2 boxes.
Yeah, the process is governed by, among others, Article 29 of the EIA Act, so the process is application comes in, concerns are raised, and the administrative authority may, but doesn't have to, give the applicant an opportunity to respond.
My question is rather, does it have to look at the concern and see whether they have some kind of justification? And I don't read it in Article 29, but but maybe you can help us.
Well, what the Article 29 does is that it has several references to,
Could we bring it up on the
sorry.
screen?
It's
It would be helpful.
Two hundred twenty-five.
Yeah. Sir, I think we're waiting for.
Are you looking for 225, the EIA Act? Yeah.
That's not.
No, it's,
C225.
yeah. I think that's it.
That's it, CC two.
That's it, yes.
That's
So let's
at
go to section 29.
page 5 of the PDF. Here it is.
So the answer is if we scroll down to subparagraph 3.
I think it would also be helpful. We just, sorry, forgive me for interrupting, but also paragraph 2 as well, I think is quite important.
Yeah.
So in paragraph 3, we can see that in making the decision if a proposed activity or its changes to be assessed under this act. So if in other words, if the full EIS is to be conducted, the criteria for screening procedures set out in Annex 10 will be used accordingly. And the competent authority shall also take into account the opinions under section 23.4. The opinions is all that we saw in the decisions sent by other organs of the state and expressions by the public. So the criteria are laid out in Annex 10. But this act actually does not specify that the level of how would I call it, seriousness of a risk that needs to be determined for the full EIA to be ordered. And so the act only lays out, what needs to be taken into consideration. And we can look at Annex 10 if we have it translated. And Annex 10 is very similar to the annex of the EIA directive.
May I just interrupt very briefly in relation to Annex 10? I would just point the tribunal to page 18 of this document, particularly part 3, significance of potential impact. that picking up on,
Can we scroll down?
yes. So on the next page, please. So page 18 of the English. Yeah, so significance of potential impact.
And it is from this criterion that you
Precisely.
based on this, that you argue that the first instance must apply some kind of assessment to determine whether there is a risk.
Exactly.
Thank you.
And then just to round it off, the importance of reading this act consistently with the directive, which provides that the criteria threshold is significant effects, and I understood that to be congruent.
And could you just, and I would only, yeah, sorry.
Would you like to comment on this?
Yes, I would like to comment just on in two respects. So first of all, it is still the case that, as I answered in response to your earlier question, that it is enough to do this justification of the assessment by reference to, so for example, as it was done in these decisions. So if there is a statement given by either another body or a statement given by the public, which in itself includes an assessment of the significance of the problem identified in the statement, it is sufficient for the organ conducting the EIA to refer to that rather than to, repeat in great detail that we agree that there is this risk and we agree that this risk is significant.
Yeah, of course, I make a distinction between an assertion that there is a risk and an assessment that there is a risk. The assessment implies some judgment on the assertion, does it not?
No, it does. My point is that this can be expressed by referring to analysis included in one of the opinions stated higher up in the decision.
In other words, whereas, therefore satisfies the reasoning requirement.
Correct.
Yeah, but not the assessment in the sense that whereas Mr. So-and-so says this and this, and I refer to Mr. So-and-so, that would not really be an assessment.
No, but I would say in light of what Mr. So-and-so stated, I ordered the full EIA.
Okay, I
is
mean,
sufficient.
let's not belabor this. We've understood the point and we will.
You just give us
So
an explanation also of Annex 8. If you go down first to page 12 and just explain to us. Annex 8 is list of proposed activities subject to the assessment of their impact on the environment. And then you see threshold values, part A, compulsory assessment, and then part B, the screening procedure, which I assume is the preliminary. Then if you go
Correct,
down to
yes.
the next page, you see section 16, drillings. If you could explain this a bit, with the exception of drillings for investigation, the stability of the soils. So that seems compulsory from 500 meters. And then I haven't quite understood because it's only screening from 600 meters or up to 500 meters. It may be there's an error in this text, but it would be helpful to understand.
Yeah, I need to see the Slovak original because as you
You
pointed
could
out,
have a
the
look at
translation is
just
inconsistent.
explain to us what, if anything, is the pertinence of this provision.
Professor Sands, if I could help you, I'm very happy to jump in. If you go to the Slovak version at page 54, C225 SVK,
Yeah.
I think there may, we have always understood this and read this to mean it may be a formatting error, but we have always read this to mean if you're going deeper than 600 meters for any deep drill, then it's screening. But in the first column, we understand that to relate to the specific types that are then set out in the bullet points, which we weren't
Yeah,
doing
so-
the drilling.
So I think the source of confusion is that the English translation should be further down.
Exactly.
Yeah.
So the 600-meter threshold applies to all drilling. So in other words, if you're going deeper than 600, but the other points are specific threshold, for example, for geothermal energy drilling for the storage of nuclear waste, water supplies, etc. That's not what we were dealing
What
with.
page is it on the C225 SVK? I've got it in front of me.
54. And I mean, it's even on this, it's slightly,
Yeah.
but that's the way we understand it.
We confirm that understanding,
Yeah.
actually. Yes. So generally for drillings, it's 600 meters for preliminary or screening. And then there are three specific categories
got it.
of drillings which are subject to different rules.
Okay, got it.
Well, that brings me almost to the end, because the one thing which I want to address now, and that is important because it follows up on the discussion we had about the significance of first instance decisions. There are 3 first instance decisions on the EIA, and for reasons which were not explained, only one of them was appealed. And the only one which was appealed is the one in Ruská Poruba, where there was no realistic prospect of finding anything. So that begs the question, why AOG did not appeal the decisions in Kriva Olka and Smilno? They could have just copy pasted the appeal they filed in the Ruská Poruba site, presumably, but they didn't do it. And we submit to you that they didn't do it because at that time they were already determined to bring an arbitration claim against the Slovak Republic. And now, whether we look at that as a point of there is no violation of the BIT by a first instance decision of an administrative organ which can be appealed but was not, or whether we look at that through the lenses of causation, meaning what harm does such a decision do if it could have been rectified on appeal but was not, we submit the conclusion is the same. AOG did not give Slovakia a fair opportunity to address the concerns that Discovery has with the content of the AIA decisions. And instead, it is transforming this tribunal into an appellate administrative body, which is supposed to judge these first instance decisions and grant Discovery tens, if not hundreds of millions of euros just because their Discovery believes that there are some issues with the first instance decisions. And we say this is not how bilateral investment treaties are supposed to operate. And that, members of the tribunal, concludes our submissions. And I am very grateful for the additional time that I was granted to finish my submissions.
Thank you. So that leads us, I think, to the end of this hearing. In terms of procedure, we will confirm your agreement about the different deadlines for transcript corrections and redactions to the video, audio, and transcript, I suppose, as well. And then the response was in a certain time as well, and then the cost submissions. Is there anything else that the parties would like to raise at this stage? Comment, questions, including complaints about the conduct of the arbitration?
Nothing from us. We just are very grateful to the care and attention that the tribunal has given to this case.
Thank you.
None from respondent.
Same questions to respondent.
We have no further comments and would like to thank the tribunal for a very well-run hearing.
Thank you. Then it remains for the tribunal to thank, first of all, the court reporter, the party representatives who sat here for very long hours on both sides, and of course, counsel for a very well handled arbitration, both in terms of the written submissions and this hearing, and also the very collegial attitude and cooperation that made our lives much more, much easier. And now I close this hearing and I wish you all some rest, I hope, a well-deserved rest. Goodbye to everyone.
Thank you.